Please give. Huh? Fresh matters you can please give.
Recall application has been rejected.
Please give it, sir.
So recall application has been rejected without any grounds.
Please give.
Arguments tomorrow. Coming up for our arguments tomorrow itself.
Please give them.
And they have it tomorrow.
Please give. No, 2:30. Please give it if it is possible. We'll have it tomorrow. Yes. Please give. Don't have to mention, sir. You please give the memo. Please give it. Please give it. Please give. Please give it, madam. Please give it. Huh? Yes. For orders. For order. Please give. Service matter. Huh? Caste certificate. What is it?
ಸಾಧ್ಯ ಆದ್ರೆ ಬರುತ್ತೆ, ಇಲ್ಲಿ ಇಲ್ಲ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ ಪ್ಲೀಸ್ ಗಿವ್. Please call out. Please call out. ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ, ಇಲ್ಲ ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ. ಕೊಡಿ, please give it. Yes. Yes. Please call out the matter. Adjournment. Yeah, the other side here.
Sir.
Preliminary hearing. PDS. Not possible. Yes.
My lord.
Huh? Yada? Who's on the other side? Huh? Only government. No. Yes. Huh? No, let us see. Yes.
My lord, serial number 42, my lord. I have intimated the other side also.
No intimation if they have to be here to say no
No,
objection.
my lord, one submission. We have given the files to private
No, I
mediation.
don't adjourn the matters unless the other side is here and says no objection. That is my policy. Yes. Yes.
Number 1, Madam.
Yes.
This is connected with the WP. 2 more common judgment, 3 judgments, Madam. Common one, they are connected 2 persons are also there. Then all the 3 arrests of the school records, Madam, the question is father, and his name is not reflected. Initial is removed. That's why, Madam, we ask for the direction.
There is no interim prayer.
Yes,
There is no interim prayer.
Madam, my prayer is the change.
It has to be listed along with.
Yes, WP 11125 of 2023 and 10,984 of 2023. Same judgment, common judgment.
10,984 of 2023.
Yes, sir.
Issue notice to the respondent. The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel appearing for the respondent before the trial court. Stop. List this matter along with WP number 31125 of 2023 and 10984 of 2023.
Yes, sir.
Huh? Password.
Spence petition, Lord.
Yeah?
Spence petition. Wait, files the petition for divorce in 2021. Thereafter, she filed the application seeking interim maintenance, my lord, for some of which 2 lakhs per month. The family court has awarded 60,000 per month, my lord. She is a qualified engineer, aged about 27 years. She does not express, my lord, why she is not working.
Why she is not working?
Can you come to
We'll ask her.
Page 70.
Issue notice to the respondent. The petitioner is also permitted to serve a copy of the petition along with annexures on the learned counsel appearing for the respondent before the trial court. Iವಾಗ ಏನ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್
After
Still before Pawan Sagar.
Yes.
Impute order is at page 25. Order confirming the provisional attachment. Not the PMA. The primary ground is violation of principles of natural justice. As the Lord contemplated under section 8(2)(b) of the PMA. Without affording hearing the Lord, the impute order at page 25 is passed. This Lord would be relevant. The provisional attachment order by R2 is dated 27/3/2023. Lordship gets it at page 114. Thereafter, my lord, the complaint
You appeared.
is, my lord.
You appeared.
Yes, I have appeared.
How you say that?
In fact, the cause, yes, I will come to that. The complaint, my lord, is dated 25/4/23, which is at page 202.
Yes.
Thereafter, my lord, what is crucial is the show cause notice. I request your lordship to kindly turn to page 306. 6 is the show cause notice. There, page, my lord, 315 is relevant. The timelines are fixed. We were not supposed to file. May I invite the participant to para 14 on 315. Para 14, you know.
Yes.
Defendants are called upon to file their written reply on the email of adjudicating authority, so and so, in MS Word as well as PDF format on or before 21st June 2023. I'll pause here for a moment, Lord. We have done this on 19/6/2023 itself, which is at page 348. Thereafter, they are also required to file the reply simultaneously on the email of the complainant, so and so. That is also done, my lord. And the soft copy is sent by email on 19/6/2023, which is at page 375. Further, it is also made clear that filing of the soft copy of reply in MS as well as PDF format is not a substitute for filing of reply in hard copy. It is mandatory for the defendant to furnish their email within 30 days of the receipt of this show cause notice. Further, a reply in hard copy along with copy of the email regarding subject of reply and soft copy must be sent to the adjudicating authority as well as to the complainant to reach them on or before 5th day of submission of reply on email as aforesaid. I have sent, my lord, my email ID on 21/6/2023, which your lordship gets it at 348.
Yes.
Thereafter, my lord, they were supposed further, in view of the time limitation involved, non-adherence to time schedule of submissions may result in non-placement of submission. Further, on receipt of reply on or before 28 June 2023, the complainant is required to file the rejoinder by 28 July 2023 in the manner stated above, with a copy to the defendant simultaneously. In this case, the opportunity of being heard through online video conferencing is provided on 22nd August 2023 at 2:30 p.m. For the purpose of availing the opportunity of being heard, it is mandatory for the defendant to furnish their email for sending a video link at least a month before the date fixed for hearing. I have done this, my lord, on 19/6/6. I have sent the email. Now I will take your lordship through the email, page 394. After sending the reply on 19th June, sending the hard copy on 19th June, they filed their rejoinder on 19/7, which is at page 376. Now kindly will not turn to page 394, annexure K. This is not from Rajat Emma, that is the petitioner. Dated, your lordship gets the date, 15th August 2023 at 6:29. Respected sir, I am here with submitting so and so, so and so, in which case I am arraigned as defendant number 8, and the same is attached to this mail as MS Word. The same MS Word document file is so and so, so and so. Further, below, kindly come to the fourth line from bottom. Since your good self has fixed 22nd August 2023 at 2:30 p.m. as the date of hearing, I request your good self to provide me the link for online video conference to my email ID, so and so, the ID through which I am sending this email. Also, kindly refer to my earlier email dated 19/6/2023, wherein I have already sent my written reply and also provided my email ID and phone number. They don't send it, my lord. Hence, I sent another email on 21/8/2023, which your lordship gets it at page 395. It is sent on 21 August 2023 at 11:40 AM. Respected sir, in this case, so and so, I'm the defendant, number
All
8.
right.
I had submitted my written reply along with the RUD in the said case via email on 19/6/2023, and also I sent the hard copy of the written reply via so and so, so and so. The matter is fixed for hearing on 22/8/2023 at 2:30 PM through online video conference. I have not yet received the link for the said video conference to address my arguments. I request your good self to send me the video
So
conference.
your contention is that the email link was not given to you, so therefore you are not able to.
Yes, and violation of section 8(2). So, my lord, I have filed my written reply without hearing. Further, I'll just complete, my lord, for sake of completeness. Page 396. On the date when, my lord, the hearing was fixed also, that day morning, 1.5 hours prior, your lordship may kindly see the date.
Yes, I have seen that. I have seen that.
Then again, I say I'm waiting.
Yes,
They don't do it.
yes.
Hence, Lord, I was under the impression that they have cancelled it because the hearing was through video conference alone.
Yes.
Physical hearing was not provided, was not contemplated rather. So 397, page 397, I sent another email on 28th August, recapitulating all the Milord sequence of events.
Yes.
398, this is a mail, Milord, dated 5th September. There I write, unfortunately, I have received no link nor any reply, even to this day, in spite of my 5 earlier mails in this regard. This is dated 5th September, whereas Milord.
It's all right, sir. Have they taken into consideration your reply and other things or not?
No, Milord, they have not. And as per section 8(2, now the impute order is at page 25.
They have taken into consideration. Please see page number 58. Reply of defendants number so and so, so and so. It includes defendant number 6.
The present petitioner is defendant number 8.
8. No, 8 separate agide. Page number 59 ali. Yes.
Page 59, they right, but will not the right of hearing as contemplated.
Learned
They have not recorded, in fact, will not.
Learned Deputy Solicitor General of India is requested to take notice for both the respondents. Learned Counsel for Petitioner is directed to serve 2 sets of copies of the petition along with annexures on the Learned Deputy Solicitor General of India. Full stop. List this matter immediately after Dasra vacations.
In the meantime, Lord, now they have confirmed and taken possession of the.
Yes, yes.
Status quo,
Not in these kind of matters, sir. No.
For a moment, Lord, for a moment,
No, no.
invite the lordship's attention to section 8(2
Yes.
of the PMLA.
Yes. PML Act would read. PML Act would read. Yes.
For that, may I invite your lordship's attention to section 6, subsection 15.
Yes. Subsection.
Subsection 15 of section 6.
Yes.
The adjudicating authority shall not be bound by the procedure laid down by the Code of Civil Procedure 1908,
Yes.
but shall be guided by the principles of natural justice and subject to other provisions of this act. The adjudicating authority shall have powers to regulate its own procedure.
Correct.
Now, subsection 2 of section 8, my lord. The adjudicating authority shall, after be considering the, my lord, considering the reply if any to the notice issued under subsection 1, that is one part. B, hearing the aggrieved person and the director or any other officer authorized by him in this behalf, and C, taking into account all relevant materials placed on record before him, when order record a finding to the all or instructed properties referred to in the notice issued under subsection 1 are involved in money laundering. So, my lord, these 3 steps are important. First step, they have taken into account my reply, but B, my lord, it is mandatory. And I am not at fault. I have been repeatedly telling them, kindly afford me an opportunity of hearing.
Now, what is the consequence of the impugned order?
Consequences, my lord, the provisional attachment order is confirmed. And then now they are proceeding to take possession of my property. So let them, my lord, maintain status quo. I have filed a detailed reply on 1966. So if you order, my lord, at 25.
There are various other persons involved.
Only against me, far against me, my lord. I have got nothing. First of all, on merits also, my lord, on merits, they rely on some other's property. For a moment, my lord, for a second, if the lordship permits me, at page 321, the sale deed which they are relying on, saying which I have mortgaged with the bank, is not my property at all. We make my lord filing, my lord, page 112.
What was the condition before the impugned order was passed? Huh?
I was in possession.
There was a preliminary.
Yes, that is the provisional attachment.
Provisional.
Procedure to be followed. Provisional attachment is at page 114, dated 27/3/2023. That is as per section 5(1) of the PMLA. Then a complaint has to be filed, not as per subsection 5 of section 5, and that is done on 25/4/2023, which is at page 202. Then show cause notice.
The senior counsel, Shri Murthy Naik, caring for the petitioners. Petitioner submits that the petitioner is defendant number 8
Yes.
in the proceedings before the adjudicating authority. Who has passed the impugned order confirming the provisional order of attachment Stop. Learned a senior counsel would draw the attention of this court to the email communications made by the petitioner at annexures K, L, annexures K to T, and submits that although the petitioner complied with all the requirements in terms of the communication made to the petitioner by the adjudicating authority in providing the email link, email ID to enable the adjudicating authority to furnish the email link to enable the petitioner herein to make his submissions online through video conference. Nevertheless, the email link was never sent to the petitioner. Stop. It is submitted that even on the previous day, that is on 21st of August 2023, the petitioner made a communication requesting for providing the email link, but it is evident from the material available on record that the email link was never given to the petitioner, and therefore the petitioner was unable to make submissions to the video conference. Stop. Learned senior counsel submits that in terms of Section 2 of Section 8 of the Prevention of Money Laundering Act, 2002, it is mandatory for the adjudicating authority to hear the aggrieved person and the director or any other officer authorized by him in that behalf, and thereafter record a finding whether all or any of the properties referred to in the notice is issued under subsection 1 are involved in money laundering. Stop. The mandatory requirement of hearing the petitioner not being followed, the learned senior counsel submits that the impugned order is required to be stayed insofar as the petitioner is concerned. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at annexure A insofar as the petitioner is concerned, till the next date of it. Mr. Prasanna Kumar. Unni Krishnan. Deputy Solicitor General for respond number 1. Learned counsel Shri Unni Krishnan is requested to take notice for respond number 2. Serve 2 copies of petition on the learned counsels for the respondents. Yes. Huh? The order is against respond number 4, is it? Learned AGA. Without notice to the other side. Without notice to the other side. I am not going to do that. Learned AGA. What interim order can be passed in this matter, sir? You are asking for implementation of the order. What interim order can be passed? Learned AGA takes notice for response number 1 and 2. ಈ ರೆಗ್ಯುಲೇಟರಿ ಅಥಾರಿಟಿ ಯಾರಾದ್ರೂ ಅಪಿಯರ್ ಆಗ್ತಾರಾ? Why do you want to make them a party?
Party because
Why
the
should-
SOP has some direction and some procedure to be followed to ensure the compliance of their judgment not being followed. I'm not seeking any direction.
How can you impede the authority which has passed the order, sir? Can we issue notice to them?
Their SOP that's not been adhered to my.
Issue emergent notice to respond number 4. Notice to respond number 3 is not necessary for the present. Full stop. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. The petitioners are also permitted to take out hand summons to respond number 4. Yes. That petition.
Let us see the order wherein 17,988.
Same order. As in WP number 21763 of 2023, dated 27th of September 2023. When did you avail the loan? 21. And so soon you are a defaulter.
There is no incident there and then. Passing the national order, this regulation is in fact. 13(6) Act, this is the group for regulation, order 78 Act is there.
Huh?
RBI's cap on the operating plan, and it can't regularly or be restructured now. If the regulation is done well,
Yes.
it has to come out of the MP. Without coming out of the MP, it can
4 lakhs is ready now.
4 lakhs of fees. So far, we have not issued sale notice. I think 30 days there, we issue notice also to take 30 days. You know 30 days. I have 45 days in there. Nothing is done.
Anyway, we will hold them by passing an interim order at his request. Within 4 weeks, let them deposit 20%.
That's 4 lakhs.
ನೀವು ಇವಾಗ ಈಗ 14 lakhs ಕಟ್ಟಿದ್ರೆ would it regularize or not? We do not know. It is for them to say. 20% would be around 14 lakhs. 70 lakhs, 73 lakhs or something is there. 15 ಅಂತಲ್ಲ ಇಟ್ಕೊಳ್ಳೋಣ. ಈಗ they are giving 4 lakhs. We will direct them to deposit another 10 lakhs within a period of 4 weeks.
Apart from this, we have to pay into lakhs.
Yes.
Other than that,
Yes. Learned counsel Shri K. Ram Bhatt. has entered appearance for respondent number 1 by filing a KV petition. Who's respondent number 2? Huh?
The borrower itself, mother, son, by the petitioner.
ಅವ್ರನ್ನ ಯಾಕೆ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ರು? ಅವ್ರನ್ನ ಯಾಕೆ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದೀರಾ? ಮತ್ತೆ ನೀವು ಜಾಯಿಂಟ್ ಆಗೇ ಬರ್ಬೇಕಾಗಿತ್ತು. ಜಾಯಿಂಟ್ ಆಗೇ ಬರ್ಬೇಕಾಗಿತ್ತು. ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದೀರಾ? ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹಂಗೆ ಮುಂದೆ ಕೇಳ್ಕೊಂಡು ಹೋಗೋದು. Notice to respondent number 2 is not necessary because respondent number 2 is the wife of the petitioner and a co-borrower. Yes. Stop. Next paragraph. Learned counsel for the petitioner submits that the loan was availed on 25/6/2021 in a sum of rupees 70 lakhs. And even according to the first respondent, the outstanding amount as on 16/3/2022 is 73,21,308. Stop. Learned counsel submits that the petitioner is tendering a sum of rupees 4 lakhs today by way of 2 demand drafts. By way of 2 demand drafts. Stop. Learned counsel would submit that within a period of 4 weeks from today, the petitioner will deposit the remaining portion of 20% of the said amount, and if reasonable time is given, the petitioner will pay the balance amount and get the account regularized. Stop. ಅಲ್ಲ ಈ 20% ಕೊಟ್ಟು ಮಿಕ್ಕಿದ್ದು ಎಷ್ಟು ಕೊಡಬೇಕು ಅಷ್ಟನ್ನು ವಿತಿನ್ ರೀಸನಬಲ್ ಟೈಮ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. Having regard to the fact that the petitioner is before this court challenging an order passed by the Additional Chief Metropolitan Magistrate, Bengaluru, 8th Additional, in Criminal Miscellaneous number 4599 of 2023. Under section 14 of the SARFAESI Act, and steps, if any, are to be taken by the first respondent in terms of the provisions of the SARFAESI Act. In the meanwhile, the petitioner may be in a position to get the account regularized. Full stop. Next paragraph. Consequently, the first respondent is hereby directed not to proceed any further in the matter of recovery of the loan amount from the petitioner, subject to the petitioner depositing the remaining of the 20% of rupees 73 lakhs so and so within a period of 4 weeks from today, failing which the benefit flowing out of this order shall not inure to the petitioner, and the petitioner shall be at the risk of having the petition dismissed. Full stop. Next para. Learned counsel Shri K. Rambhat has received the 2 demand drafts totally for rupees 4 lakhs at the hands of the learned counsel for the petitioner. Full stop. Next para. Release this matter on 15th of November. Rera. Not functioning.
the complainant to sought refund of the deposits made by his email at page 140. Counter, he has lost his job itself, therefore he is employed. Then one of the project has been completed, it has been then he came in March 2022 and said that he will take the review. And once his rights are completed with the system that we got the adjudicating for reason for withdrawal. Then once we contended, when the application came, when the complaint came before the authority, we said no, authority has got very good to understand. Only in two circumstances, where I have not completed this project, or where I have gone out of this. Both are not done. If both these conditions are absent, it has to go before the adjudicating body. That complaint was correctly filed before the adjudicating body. By a mistake of the judgment in Newton, they rendered the reason for that. Seeking refund for withdrawal. It is a simple thing which does not require any adjudication. Therefore, if 18(1) is satisfied, those complaints can be entertained by the bureau, though it is not legally right. Only remain you can go before the adjudication. Now, section 18(1), it contains two arguments. One is no where.
Which is the impugned order?
Impugned order is election given. Where under 18(1), it passes the order page 89 and grants refund from the interest from 2014. Under 81 or under 81, I am required to pay interest only for the period of delay. That too, if it goes before the adjudicating. Now it says most kindly see the order part, which is at page the operative procedure page 86. The interest itself that the calculate it comes to years. 78 lakhs 49,881 and further interest. Actually, I have completed the construction in 2018. As against the date available to me as 31st of January 2019.
You have completed before time.
I have completed before time. I have issued him letter that to take possession in December 2018. Not under this act, for giving delivery, it is enough if I have completion certificate. Occupancy certificate is required for immediately same. He comes and instructs and then he doesn't take delivery. Then what, sir? It cannot be entertained within 18 and a half, but all it comes under section 71. It entertains the complaint under section 18. And directs you to pay a total sum of 2,24,81,122. If I have completed and then delivered and then paid up for dates, I have mentioned at page 2.
But those dates are not taken into consideration by
Those
the.
dates are not taken into consideration. He says that I have failed to deliver. Subsequently, what happened?
The respondent has taken extension of 6 months.
6 months in the sale in the agreement itself. There is called as grace period. Grace period ends on 31/1/2019. You may want to kindly turn to page 1, my lord. The dates and the events.
The respondent has obtained occupancy certificate on 3/10/2019.
Yes, my lord, occupancy certificate. I have got time. After delivering, after obtaining the occupancy certificate, within 3 months thereafter, I have to execute the sale date. For delivery, what is required is completion certificate. All those things have been ignored and this order has been passed.
Issue emergent notice to all the respondents. Next para. Senior counsel appearing for the petitioner submits that the petitioner is before this court invoking the writ jurisdiction though there is an alternative efficacious remedy available, only because the appellate authority is not functioning for want of quorum. Other. The learned senior counsel would submit that even in terms of the findings of the regulatory authority, which was not required to entertain the petition at the hands of response number 2 and 3. Nevertheless, it is found that the authority has noticed the fact that the petitioner has obtained occupancy certificates on 3/10/2019. Stop. The learned senior counsel would therefore submit that the authority could not have entertained the plea of the petitioner for withdrawal from the project, while pointing out to the delay on the part of the petitioner in handing over possession of the residential apartment. Stop. Furthermore, it is pointed out that the authority has directed the petitioner to refund the entire amount along with interest calculated from the date from which the contesting respondents paid the installments, that is from 21/4/2014 although admittedly there is no delay on the part of the petitioner, and even if there is any delay, it may be about 3 months at best. So, next para. Consequently, there shall be an ad interim order of stay of the impugned order at Annexure E. Dated 17th of August 2023, till the next date appearing. Yeah.
For the parents of the deceased Karthi,
Claim petition.
the parents of the claim petition, the pleading applicants respond to the plea for the pleading application before the tribunal. They find the application stating that they are the parents of the deceased, aunt and uncle of the deceased. That application came to be allowed by the tribunal. So they are not the legal representative of the deceased. Do not mention the email of page number 35. Meant by the respondent number 3 and 4 hearing. For the application before the tribunal, by the application under 1 to 10. Stating that they are the legal representative of the deceased. No document furnished by them to show that they are the legal representative of the deceased. Application came to be allowed by the tribunal. They ignored by the same and ignored this petition. Observation made in paragraph 5 include ornament. Very next.
Uncle and aunta.
It's on which the application came to value.
Ah.
After they are produced several documents that show that the petitioner and the biological parent of the disease. It is from next document. Fulfill of there are dependent on the early of the disease. They are declaring that
They are not biological parents of the deceased Karthik, and further admitted that the deceased Karthik is their foster son. A suppressing material fact.
At the time of adjudication of the claim has to be determined whether they are the legal representative or not. Based on that observation, that application came to biological. Why they have substantiated that status that they are the legal representative of the disease. Based on the passbook and other geological tree, they have enlightened their case that they are the legal representative of the disease. But the eminent cooperative decision and judgment are supposed to be pronounced in the next date of hearing. Okay, let me tell you from the 36 to 30. Do the certificate of the Karthik where it indicates that I have to carry it also will include certificate. The marker. On these documents clearly indicate that the lecture of the parents of the
Issue emergent notice to the respondents. Next para. Learned counsel for the petitioner submits. Idian annexure order.
earlier a single line on that has been participated without any observation. So, application by the respondent has been demanded to for reconsideration.
Learned counsel for the petitioners submits that by passing the impugned order at annexure P, the learned judge of the Motor Vehicle Accident Claims Tribunal, Kamat Hassan, in MBC number 738 of 2019, has allowed IA number 4 filed at the hands of respondents number 3 and 4 herein, and permitted them to be brought on record as respondents number 3 and 4 in the claim petition filed by the petitioners. So, learned counsel submits that the contesting respondents have not disputed the fact that petitioners number 1 and 2 herein are the biological parents of the deceased Sri Karthik, who died in a motor vehicle accident which occurred on 12/1/2021. 20? ಇಲ್ಲ. Huh? 27/9/2018. 2018. So, however, the contention of respondents number 3 and 4 that they are the foster parents of the deceased person has been upheld on the ground that the term legal representative, in the context of the motor vehicles claims cases, cannot be given a restricted meaning. Stop. Next para. Matter requires consideration. We'll stop. Consequently, there shall be an ad interim order of stay of the impugned order dated 12/9/2023 at annexure P and all further proceedings in ABC number 738 of 2019, comma till the next date of hearing. When did you take the loan? Huh? 21. And so soon you are a defaulter. Huh? How did you offer your agricultural properties as security? If that is the contention. Then they will take symbolic position. Ashtetane. Let them take. ಎಷ್ಟೋ ಪ್ರಾಪರ್ಟಿಗಳು ಇದೆಲ್ರಿ ಒಂದಲ್ಲ. There are many properties here. That cannot apply to all the properties. ಯಾವ್ದ್ರಲ್ಲಿ ಡ್ವೆಲ್ಲಿಂಗ್ ಹೌಸ್ ಇರೋದು? ಯಾವ್ದ್ರಲ್ಲಿ? Issue emergent notice to the respondent. Stop. Learned counsel for the petitioners submits that the petitioners await loan from the respondent bank in the year 2019. 2011 na. ಎಷ್ಟಕ್ಕೆ? ಎಷ್ಟು ತಗೊಂಡ್ರಿ? 7,86,000. In a sum of rupees 1 crore. 7,86,000. Stop. It is only after the COVID-19 pandemic and the lockdown that the petitioners were not able to pay the EMIs regularly. Stop. Learned counsel submits that even according to the petitioners, respondent, the outstanding amount is in a sum of rupees 1 crore 63 lakhs. for 43,244. Stop. Learned Counsel submits that the immovable properties mortgaged are agricultural properties, and if possession is permitted to be taken, the petitioners will not be in a position to generate income. Stop. Moreover, in one of the properties in question, the dwelling house of the petitioners is also located. Stop. Learned Counsel would submit that if reasonable time is granted, the petitioners will pay the amount to get the account regularized, and thereafter they will continue to pay the EMIs regularly. Will stop. In order to show the bona fides of the petitioners, it is submitted that the petitioners are ready and willing to deposit 20% of rupees 1,63,000 or 1 crore 63 lakh so and so within a period of 4 weeks from today. Will stop. Next para. Consequently, the respondent bank is directed not to precipitate the matter any further. Consequent to the impugned. Possession notice at annexure B, subject to the petitioners depositing 20% of rupees 1 crore 63 lakhs 43,244 in a period of 4 weeks from today with the respondent bank, failing which the benefit flowing out of this order shall not inure to the petitioners, and the petitioners will be at the risk of having the writ petition dismissed. We stop. Release this matter on 15th of November. Huh? Where is the copy of the petition? Page number 12. ಹೊರಗೆ ವಾಸಿಸುತ್ತಿದ್ದು ಜಮೀನಿನಲ್ಲಿ ಸಾಗುವಳಿ ಮಾಡಲು ಸಹ ಬಿಡದೆ ಜಗಳ ಮಾಡುತ್ತಾನೆ.
I am also participating against the mother and sister. That route is not very protection of the cultivation only one part of the appliance.
ನೋಡಿದ್ರಿ ಪಿಟಿಷನ್
ಅದಕ್ಕೆ ಇವಾಗ ಈ ರೀತಿ ನಮಗೆ ದಯಾಮರಣ ಕೊಡಲಿಕ್ಕೆ
23 ಇದು ಪೇಜ್ ನಂಬರ್ ಯಾವುದು?
Right from the start from case 20. That is the complaint. Harassing her mother and not permitting her to. Allegation is not permitting her to reap her own crop cultivated in her own property. ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಎಲ್ರಿಗೂ ನಾನು ನ್ಯಾಯವನ್ನು ಕೊಡ್ತೀನಿ.
Allah, type copy of annexure B, page number 22 is the reply. It's a reply given by this person. Karunakar. That is not the petition. ಇಬ್ಬರಿಗೂ ಸೇರಿ ಇವಾಗ 4,000 ಕೊಡಿ ಅಂತ ಹೇಳಿದಾರ. Each 4,000. After all, you were giving it to your mother. Let us see. Learned AGA takes notice for response number 2 and 3. Issue emergent notice to respond number 1. Learned counsel for petitioner is directed to serve a copy of the petition along with annexure from the learned AGA. ನೀವು ದುಡ್ಡು ಕೊಟ್ರೆ ಯಾಕ್ರೆ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ? 4,000 ಕೊಡ್ರಿ ಏನಾಗಲ್ಲ. ಎಸ್ KSFC. You have to go to the civil court. KSFC. You have to go to the civil court. Huh? Huh?
The grievance is regard to value of the property being high.
Yes, madam.
Application to the corporation asking facilities like order of sale of property and enforcing of liability and this. Industrial consent selling the property and the remedy, there is no remedy that is available to the industrial consent.
ಕೊಡ್ರಿ KSFC act are the relevant provisions.
Section 31, Your Worship. Section
Yes, they have to approach the district court. They have to approach the district court under section 31. They have gone before the district court. Please read section 31. Any officer of the financial corporation, generally or specially authorized by the board in this behalf, may apply to the district judge within the limits of whose jurisdiction the industrial concern carries on the whole or a substantial part of its business for one or more of the following reliefs. Without approaching the district judge, how are they proceeding? You have to bring the complete information. Yes. It is. If that is not a matter that can be concerned by the district court, only then you can say no, the district court has no such power, and therefore we are before this court. I don't see any such thing. Issue emergent notice to the respondent. Yes. Yes. Page. Page 1. Then what is the matter about?
When we come to the next page, 123, not come, there is a sale notice to action by house.
You are a borrower.
Yes. Make sure marks and the price. He was granted loan, cash credit facility. It was enhanced also. The primary security is. In page 47, not in the sanction letter. No guarantee is required. The credit facility is guaranteed by. Sitting facilities were secured by EM of IPs worth 109 lakh. Party has requested that the facilities to the existing thing be covered under CGT MSD so that the EM of IP can be used for another use. Which means they are proposing to short the request of the party accepted and the proposed existing and enhanced facilities of the unit be covered by guarantee of CGT MSD. Guarantee first micro, small enterprises.
Hmm.
Entire entity is covered by.
All right. He was given and direction was given to the respondent to consider your representation.
Yes.
What happened? Rejected.
Now here, that party has taken 1 loans, work liability is added, it's 3 something like. Now this sale will be showed, or that there was security given for selling the market property, they will be shown. Now this sale is my lot, is a account has been moved into 60. And upon request of 500, that will depend my lot. Now my lot, all this work put together my lot, now come to 2 or something. Now, tomorrow is sale. And today, this is come up again. Now, I got this part because I do that affects now only my question is, I will permit the condition of property, that will not confirm the sale, and then the court passes some order, so that let them take me. Now, this is going from 16 hours, this is the value of my how.
Yes, sir.
First, I have to restart the. There was a direction by the ministry, industry, everyone. They are not compliant. Never taken. They took up one objection or the other. They wanted assessment to be made, projections to be made, not out of competency. Everything was done from 2017 till date had been.
Which is that order? Which is that order of which there is not compliance of the bank? You said there is an order. You said there is an order directing them to do certain things.
Yes.
Which is that order?
Page 105. This is the development commissioner, Ministry of Micro. In February 2017, there is a direction.
Just have to kindly look into the issues raised for appropriate action under intimation.
In projection, so CA one is finally incorrect.
Yes. Learned.
54790 insurance sale notice.
That is job. Which I read to the court.
Yes, yes.
And made.
Annexure Z. Then council. TP Mutanna. T for train. TP Mutanna undertakes to file wakalat for response number. Submits that he has already filed wakalat on behalf of response number 123 Punjab National Bank, in the office this morning. Please stop. You want notice to be issued to respond number 4?
Not just, I am agreed of the same route, I am agreed of the inaction of the use. That.
Issue notice. Issue notice to respond number 4. Learned counsel for the petitioner submits that earlier the petitioner was before this court in WP number 5478790 of 2018. Seeking a writ of mandamus directing the respondent bank to consider the representations given by the petitioner for consideration of rehabilitation and revival package in terms of the policy of the union government, of the government of India in respect of MSMEs, micro, small and medium enterprises. So, during the course of the proceedings, although a e-auction sale notice dated 30/10/2018 was issued by the respondent bank. Nevertheless, it was submitted that the sale was not successful. Stop. Recording the submission of the learned counsel for the respondent bank and the direction to the respondent bank that it shall consider the representations given by the petitioner and pass appropriate orders, the writ petition was disposed of by order dated 5/9/2019. Stop. Learned counsel submits that in spite of specific directions being given by this court, the respondent bank has not considered the representations of the petitioner and has once again issued a e-auction sale notice dated 26/9/2023. Stop. Next para. For contra, learned counsel for the respondent bank submits that the representations of the petitioner have been considered and has been rejected, while complying with the directions issued by this court. Full stop. Nevertheless, the learned counsel would submit that the account of the petitioner became NPA way back in the year 2016, and till date, no attempt is made by the petitioner to get the account regularized. On the other hand, attempts are being made to stall the auction proceedings initiated by the respondent bank in accordance with law. Full stop. Next para. Consequently, the respondent bank is permitted to go ahead with the auction scheduled to be held on 11/10/2020, 12/10/2023. However, the sale shall not be confirmed without the express orders of this court. Full stop. In the meanwhile, the petitioner is permitted to deposit Sir, if you are prepared to pay some money, some relief can be given to you. You ಏನು ಮಾಡಲ್ಲ ಅಂತಂದ್ರೆ we also cannot do anything. That's all right, sir. Whatever it is, you please go and sit with the bank and see how best it can be sorted out.
I have been continuously doing that. My unit is closed. Unit is closed. And I have been trying. I took my chartered accountant. I took evaluator.
Yes.
To assess my ability to produce.
Then you have to invoke the provisions of the MSME Act and go before the competent authority. Nothing can be done before this court.
In case I become a departner for recovery, they have to invoke the MSME provisions and get the money from. Entire amount is secured by insurance.
Housing loan was. Other rules are there. You are talking about MSME, but there are 5 loans. Out of 5 loans, my learning is starting with 1 loan. Housing loan sanction get into 5. And other.
The MSME is only one loan.
Now they are talking.
Mikit bere? What are the other loans?
One is housing loan includes on 5, another 3 loans. This is only 1 loan you are talking about. 5 loans.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದರಲ್ಲಿ. The learned counsel would also submit that the loan serviced to the petitioner on account of the MSME is only one loan, whereas there are 4 other loans obtained by the petitioner not being under the provisions of the MSME. So lastly, in the meanwhile, the petitioner is permitted to deposit a portion of the outstanding loan amount with a representation to the respondent bank to give the petitioner reasonable time to repay the loan amount, while reviving the unit, which would enable the petitioner to run the establishment and pay the EMIs to the respondent bank. Full stop. Yes. No, now they will not be able to do it. Let us see. Yes.
Committee of the third respondent part, it's a society registered under the Society Registration Act. Third respondent is the society registered under the Society Registration Act. Third respondent. The bylaws of the third respondent society provided the executive committee will have a term of 2 years from the date of election. The last date of election was 28 March 2021. So therefore, the term expires on 28 March 2023. The bylaws also provide that 60 days prior to the expiry of the term, they must call for the election process. That they should have initiated the election process in January itself. But 28th of March, they don't go ahead and do the election process. Therefore, in fact, they ask for appointment of an election officer. The government appoints an election officer. Then there's a provision to seek for extension of 2 months to conduct the election. That term also expires. Now, my lord, the committee which is no more in existence wants to call an annual general body meeting as per the impugned annexure. Lord, tomorrow, that is October 12th, for the purposes of holding an election, they would have no jurisdiction at all. So please take note section 27A. The Societies Registration Act. Once the term comes to an end, they cease to operate as a governing body. And the only option is for an administrator to be appointed. And it is this administrator who should conduct the election. It is also the view taken by the Lord. Another single bench of this honorable court and Lord a division bench of this honorable court. Piece number 27A, notwithstanding anything contained in this act, but please see B, where the term of office of the members of the governing body of the society has expired and a new governing body has not for any reason been constituted, then there will be an administrator who will be appointed, who will take necessary action to convene. Please look at subsection 4. He will convene the general body meeting and hold elections for constituting the governing body.
But how is this writ petition maintainable at your instance?
I remember. And therefore,
it's a dispute between you and the society.
Yes, Lord. So therefore, my Lord, now that an election officer is appointed by the department, now, my Lord, despite that, if they are going ahead, this is the only remedy I would have.
Election officer is appointed by the department.
Yes, Lord.
And he is not conducting the
He is
election.
not conducting the election.
Then,
but they are conducting the so-called previous body is now calling for a general body meeting tomorrow. When their term has ceased to exist, that is my grievance. But we see their own representation. Lord, annexure N.
where is the order of appointment of the election officer?
Page 57, annexure N, my Lord. They only ask for appointment of an election officer.
Yes.
Annexure N, my Lord, page 57.
Yes.
This is dated 17th of March 2023. But please see, Adesha, ಉತ್ಪನ್ನದಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ನು ಗಮನಿಸಲಾಗಿ ಫೆಡರೇಷನ್ ಆಫ್ ಇಂಡಿಯನ್ ಗ್ರಾನೈಟ್ ಅಂಡ್ ಸ್ಟೋನ್ ಇಂಡಸ್ಟ್ರಿ ಈ ಸಂಘದ ಗೌರವ ಕಾರ್ಯದರ್ಶಿಗಳು ಮನವಿ ಪುರಸ್ಕರಿಸಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಚುನಾವಣೆಯನ್ನು ಸಂಘದ ಬೇಗ ರೀತಿಯಲ್ಲಿ ನಡೆಸಲು
Yes,
So therefore, my lord, in March 2023, he has been appointed.
yes,
Any action that he has to take, my lord, will be for the purposes of convening a general body meeting and holding election.
yes.
Now, please see, my lord, the AGM notice at page number 59. It is not issued by, my lord, the election officer. It is issued by a person, my lord, who claims himself to be the general secretary. Page 59. That was after, my lord, expiry of his term in March itself.
Yes, sir.
After the period was came to an end, returning officer was appointed on 17/3/2020. If we give a schedule of calendar records to the returning officer, he has approved and he will be conducting the election. We are not conducting the election. Schedule is also.
Then the notice for election should have been issued by the returning officer. General body for what?
Only for. Page 715.
Hmm.
It is submission of revised schedule to the conduct of election at page 16. Page 17. Page 17, at the bottom. This calendar event is approved. Now, this will take place on 20th October. The election will take place. Issue of notice calling for nomination along with the request form will start from 20th October. This 12th of this month is open to approve the audit report.
Page number 14, 17 and 18 are issued by the election officer.
This page 17.
17 and 18 are issued by the election officer.
Election officer, now this Pawan Kumar will be appointed by the registrar officer.
Yes.
Technical election is there not in the general body. It will be independently conducted. And the other petitioner is one person again through there are proceedings to terminate him from membership. He has approved for the all the entire general body is not able to discuss the context. He can also participate.
Yes.
And he has already had the election being conducted. General body meeting, they cannot call. PC 27/4 has to be called by the administrator itself. But election let him conduct. I'm not coming to the election being conducted by the election officer. In fact, that is the prayer also. 27A4. PC, it is the administrator who should take necessary action to continue the general body meeting. 27A4.
But in the proviso,
Yes.
it says, provided for reasons to be recorded in writing, the state government may, by like order,
Yes.
extend either prospectively or retrospectively the said period by any further periods not exceeding 6 months at a time.
That 6 months is also over. That 6 months is taken as 28th of March. 29th of September it is over. Assuming not, then there should be a specific order extending it by 6 months. There is no specific order.
Yes.
Because my lord, already an election officer is appointed in March. Therefore, my lord, it is the administrator, the election officer who should be, my lord, calling for the general body meeting. Because my lord, they cease to subsist after 28th. That is our grievance. We are not coming, we are holding elections. We will participate, you know, what happens. But
No. If the term of the managing committee has expired, it will not be permitted to hold the general body. That is the contention. No, those decisions, no, those decisions are in case where the society is normally functioning. In such cases, yes, yes.
Registrar also has permitted here given a schedule. Now, general body agenda we can give it.
Hmm.
It is only unless the accounts are put with the general body, we cannot.
ಅದನ್ನ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. You cannot do that ಅಂತ.
NDC section 25.
Yes.
The registrar not has power to commit to hold the general body also. NDC section 25. Clause C. You brought it to the notice of the registrar. And here also filed already petition before the registrar, it is pending.
Yes.
25 of clause C. He may notwithstanding anything contained in this act or any rule, regulation prescribed in the period of notice for the general meeting. Require the governing body of the society to call a general meeting at such time and place at the headquarters of the society.
All right. Is there any such direction? Is there any such direction?
No, they will not be brought to his notice.
Allah, merely bringing to his notice agadilla.
And he has already on the very same issue. When they see the petition, on the very same issue, petition itself is not mentioned on the file. On the very same relate, petition is filed before the sub-registrar. The document which I just now filed. Page 21. Page 25.
Sub-registrar. ಅದೇನ್ರಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್? ಹಾ? ಹಾ.
Page 25.
ಹಾ. ಹಾ.
The prayer is an order directing officers to conduct election with the respondent to the of the year 2020. Even the refusal to conduct election appointing the administrator. Because in no, when the tomorrow is the election, tomorrow is the general body.
No, there is no difficulty in holding the election. That is what he is saying. There is no difficulty. Let them hold the election.
So I will have to approve the financial and then you are placed to put it.
That is in the normal circumstances. No, in the normal circumstances, that is how it happens.
Yeah.
In the annual general body meeting, where the election also is a part of the agenda. Yes.
General body, same general body meeting, election will take.
Correct. Normally, that is how it is done.
This general body is being done separately, election is being done separately.
ಅದನ್ನ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ. Since the term of the committee has expired, you will not be permitted to hold the general body. That is the contention.
So that's what we have brought it to the notice of the.
Merely bringing to the notice of the registrar will not. There should be an order. You read out a provision. If there is an order permitting you to hold the general body meeting, then you will be permitted.
What happens is, they should have passed the order, they have not passed the order.
Yes.
Now what the time will not when the entire process of election is started. General body meeting is already held tomorrow. To stop the general body below at this time end of the process, that is now it's a different matter with the general body.
Once the elections are held, the new committee will come into existence. The committee will take care of it. Yes. Yes. ಹೌದೌದು. ಅದನ್ನ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ದಟ್ ಇಸ್ ಕಂಟೆನ್ಷನ್.
Society is democratic, ultimately majority of the persons who are administrative appointment, what will it do?
They are not asking for appointment of administrator. Now, since the elections are scheduled to be held, let it be held. There is no difficulty.
General body election is process is whatever is related to allowed to
Ye-
take,
Yes, yes.
it is subject to approval of the national body. That whatever they do with this auditing financial record, that need not be treated as final until it is approved by the next report. The only the approval of the audit and account. That's all. The lordship can say, the lordship can record my submission.
All right. Perfect.
Point out, sir.
Learned AGA takes notice for response number 1 and 2. Learned counsel Shri Yeshu Mishra has entered appearance for response number 3 by filing a caveat petition. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. One more you will to give. Eli.
But 27A in the law says notwithstanding anything contained in this act, that is first aspect. But division bench has said, my lord, once the term is over.
No, that is why will ensure that even if such a meeting is held,
Yes, my lord.
nothing further will be done. No such a resolution will be placed before the registrar. Since elections also are being held tomorrow,
Elections tomorrow, 20th.
therefore, you want to hold the general body tomorrow. All right. Learned counsel for the petitioner submits that it cannot be disputed on the part of the third respondent, Federation, that the term of the previous managing committee has expired. Stop. It is submitted that by order dated 17/3/2023 at Annexure L. Annexure M, a returning officer has been appointed to hold the elections to the third respondent Federation. Stop. Nevertheless, while the election officer has issued calendar of events for holding the elections on 20th of October 2023.
Elections on 20th October.
Hmm.
The election will be held on election counting on the election will be held on 6th January, 2024.
Nevertheless, while election officer has issued calendar of events for holding the election on
Election of officer is issued calendar of events calling for submission of the nomination papers on 20th of October 2023 and the elections will be held on 6th of January 2024. Come on, nevertheless, the third respondent Federation come on through the General Secretary has issued the impugned notice of the 40th annual general meeting of the Federation on 19th of September 2023, come out to be held on 12th of October. Stop. Other 19th September. Learned counsel for the petitioner would therefore submit that when admittedly the term of the previous committee has come to an end, it is impermissible in law for the managing committee to have issued such a meeting notice to hold the annual general meeting. Stop. It is the contention of the learned counsel for the petitioner that in terms of section 27 capital A of the Karnataka Societies Registration Act, 1960, it is only the administrator who is permitted to hold the annual general body meeting. Stop. Learned Counsel submits that the petitioner has no objection in the matter of holding the elections in terms of the calendar of events announced by the returning officer. However, the petitioner is raising objection to the holding of the annual general body meeting at the hands of the non-existent managing committee. Stop. Next para. Per contra, learned senior counsel Sri Ashok Harnally, appearing for the third respondent, submit that the petitioner had already approached the registrar of cooperative societies. Registrar of
Cooperative societies ke recharge ಕೊಟ್ಟಿದ್ದಾರೆ.
So ಹಂಗೆ ಆಗಿರೋದು. There is no such registrar of cooperative societies in a complaint which is registered as DRB-4 SOR bar complaint bar 14 bar 2023-24 with a prayer directing the office bearers of the executive committee of the third respondent society to conduct elections to the respondent society and in the event of the elections not being held, to appoint an administrator for overseeing the activities of the third respondent society. Stop. In that view of the matter, it is submitted that the registrar is empowered in terms of clause C1 of subsection 2 of section 25 of the Act to direct the governing body of the society to call a general meeting at such time and place to determine such matters as may be directed by the registrar. Full stop. However, when the learned counsel for the petitioner pointed out that no such orders are passed by the registrar, the learned senior counsel appearing for the third respondent would submit that without the accounts, audited accounts of the society being placed before the general body to seek its approval, the society cannot hold the annual general meeting or elections to the society. Stop. In that view of the matter, it is submitted that moreover, it is submitted that in terms of the impugned notice, the members of the third respondent society have already come to Bangalore from across the country. And at this juncture, if the meeting is not permitted, it would cause great hardship to all the members of the society. Only at the instance of one member who is before this court. Will stop. The learned senior counsel would therefore submit that the meeting should be permitted to be held, but this court may impose a condition that the resolution passed in the meeting shall not be given effect to or placed before the registrar till the new committee is formed after the elections are held and the newly constituted committee approves of the said resolution. Full stop. If there is any objection on the part of the newly formed committee, the same may be brought to the notice of the registrar. Full stop. Next paragraph. Having heard the learned counsel for petitioner and the learned senior counsel for respond number 3, this court is of the considered opinion that the submissions made by the learned senior counsel may be accepted. Full stop. Even if the annual general meeting is held tomorrow as scheduled in terms of the impugned notice at annexure T, however, the resolution passed in the meeting shall not be given effect to or it shall not be placed before the registrar for approval till the newly constituted executive committee is put in place in terms of the calendar of events issued by the returning officer. Full stop. What anything that let the correct. All right. Nothing will be given effect to. Nothing will be given effect to. It will be given effect only by the newly constituted committee. Yes, yes. So if they have any objection, they will say, no, we will not go by the previous resolution. They will pass a new resolution. I have already said so. Next part. With this, the writ petition itself stands disposed. Yes.
But this may be made known to the members tomorrow. This may be made known.
The orders passed by this court shall be brought to the notice of all the members in the annual general meeting held to be held tomorrow. Yes. All.
Yes,
Granites and traders.
No, that is one plot, but the collateral which is offered is a commercial property for which the 32 notice is sent out. It is a page number 22 plot. That is the 32 notice, possession notice, usually issued. The comparison of two schedules for schedule A, the details of the loan, and schedule B is about the security, secured asset, it was taken as security.
Ready to take the loan?
So that date is also the date of sanction in the first tabular column. And so that of course 22 or 20 notes, there are 3 MSME notes, number 1, 2, and 5 is taken in 70, 80, and 90.
GCL is not global academic function. They rank themselves as opportunity for 40 lakhs and 20 lakhs. Because the total loan is not runs around 2 crores 60 lakhs now. I have paid almost till the year 2019 and 20. Because in the next installment could not be divided only for the reason that not enforcement the hotel industry to the global bank. Go to the bank. Revive product and loan input are accepted to the revive maintenance period. But not considering my request not acknowledged next year, saying that they are going to take position by 30 tomorrow. The input are accepted and to pay notes. Now,
No, it cannot be. You are a granite trader.
Not made but the notice is due to the hotel. As I pointed out, but also the question of
22 na. ಅದ್ರಲ್ಲಿ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ?
schedule B.
ಅದರಿಂದ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ?
That is the possession notice taken in tender. The property which is operational commercial property. That is where not I run the I'm running the hotel business and hotel and not in boarding and so hotel is now function. So this also private the right is also not in sense.
What are you challenging here?
I'm telling next year again, not
Annexure A.
property. Last priority. The said property is not.
They have obtained an order from the magistrate.
Magistrate, they have to obtain an order, but they have taken, they have sent this.
Yes.
And they have given it, like, they do not solve. In 10, they have to go if not vacate, they'll take possession of the property. All that time taking this process. I'm ready to revise it all on. But I'll make regular EMI payments. 2.6 is the liability what they have cash on me.
Sir, you have to deposit 20% now.
25 lakhs immediately deposit.
ಆಗೋದಿಲ್ಲ. There cannot be any reduction in that.
30 lakhs.
No, 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 no.
50%. Then revive ಮಾಡ್ಕೊಂಡು then I'll regularly pay for that. Give that 180 in 100,000 to this quarter. Okay, but especially the hotel industry is the worst state in the entire pandemic. The reason was I could not. That's why the new one.
This court has been consistent in saying 20% within 4 weeks. I can't go below that. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. And you are a businessman. ಆಯ್ತು ಕೋವಿಡ್ ಇದ್ರದೆಲ್ಲ ಮುಗಿದು ಏನು 2 ವರ್ಷ ಆಯ್ತು ಆಗ್ಲೇ ಬರೋದಿಲ್ಲ. Issue emergent notice to the respondent. If a learned counsel for the petitioner submits that the impugned notice at annexure A dated 6/10/2023 has been issued by the respondent bank calling upon the petitioner to hand over physical possession of the commercial building where the petitioner is running the hotel business, hotel and restaurant. So learned counsel submits that if possession of the building is permitted to be taken, then there will be no source of income for the petitioner, and the petitioner will not be in a position to clear the outstanding loan amount. So, learned counsel submits that if the petitioner pays a sum of rupees 26 lakhs, it would regularize the account, and therefore the petitioner will ensure that 26 lakhs is paid and the account is regularized within a reasonable time. Full stop. Consequently, the respondent bank is directed not to precipitate the matter any further in the matter of recovery of the loan amount from the petitioner. Consequent to Annexure A, notice, subject to the petitioner depositing a sum of rupees 15 lakhs within a period of 4 weeks from today with the respondent bank. Failing which, the benefit flowing out of this order shall not inure to the petitioner, and the petitioner will be at the risk of having the writ petition dismissed. Full stop. Release this matter on 10th of November 2023. Yes.
Deepak Bhaskar.
Petitioners are minority shareholders, respond number 2 company. This speak weight of the majority shareholder, respond number 9 is the ongoing statutory audit. However, what is happening is the petitioners had filed a company petition before the National Company Law Tribunal last year, which is pending, alleging various instances of operation and mismanagement of the respond number 2 company. Certain interim relief was granted by this honorable court, was confirmed by the Provisional Act as well. One important contention I take in that company petition, my lord, is that various statutory declarations have been falsified. To that end, my lord, an FIR was registered this honorable court in 482 jurisdiction, refused to stay in the investigation. With that in mind, my lord, if we see page 218, this. I just right, madam. Petition.
Huh?
To file an application NCLT. NCLT is not taken to come with petition. Of course, it becomes last time also they done the same thing. And your lordship done the previous your lordship is passed more than like your lordship please see page 218 for me. Because this has financial implication, statutory declarations. How also by file an application, NCLT next day come to the report saying they not by it. I think CM please justify this filing. Page 280. Page 280, my lord, is form number NGD 7A. This is a statutory filing that has to be filed, certifying that an annual general meeting is conducted and the board's financials have been approved. My lord, if we see page 219. 219, my lord, the financial year from 1/4/2020 to 31/3/2021. Whether annual general meeting was held, it gets date of AGM 29/10/2021. In my company petition, my lord, I specifically about this meeting never happened. This document is false. Now, my lord, we please see the include notice, which is that page 394, volume 2.
Is it the previous order that had passed?
Please, my lord, previous order is at page 388, where my lord, the AGM was convened for this year's financial year. Lordship had clearly stated that let the AGM go on, the final resolution will be subject to the outcome of the company petition. EGM, sorry. Extraordinary general, not annual general. Extraordinary general. Okay, please see page 394. This is, my lord, a notice. My lord, we see paragraph 1.
That is in the matter of appointment of the
No, my lord,
chartered account.
receive, yeah, that is correct. That was the previous petition. My lord, may now please see page 394. I receive a notice, paragraph 1 will be looked at. To receive, consider, adopt the audited financial statements of the company for year ending 31st March 2021.
On the one hand, you have filed a declaration saying AGM has been convened and financial statements have been approved for 2021. Now on 25/9/2023, they seek to convene an EGM to approve those financial statements, thereby vindicating the very allegations I made in my company petition that no meeting was conducted. This is all a product of forgery. Now, my lord, please see, my lord, I have filed interim application, interlocutory application for the NCLT. Asked on 5th October. The matter was discussed on the NCLT on the 6th of October. I asked the NCLT to stay this notice, and I also asked that the NCLT please to undertake an independent investigation into the affairs of the company. Given these glaring discrepancies, the NCLT said we don't have time to hear it. We will adjourn to 30th November. The AGM, my lord, is scheduled for 18th of October. So therefore, my lord, I have no other remedy other than to approach this honorable court in the jurisdiction. If in fact, if your lordship would please to pass the similar order as the previous petition, where let the AGM go on, it's only for this purpose. Let the outcome of any resolution be subject to the NCLT decision in the company petition. Just I think my one clear can be alleged. I have only one. These are statutory forms. It's an offense under the IPC as well as the Companies Act. Public institutions might rely on these declarations. If the company were to go for what taxpayers' money, my lord, is lent on the basis of these kind of declarations. That is, my lord, the only concern.
What is my reference argument? My reference argument is that the earlier form that was filed is not correct.
So there was no filing itself was forced.
Filing was forced. Let me take this argument to you. Filing was forced, filing was incorrect, it was all wrong. Now he says his argument is fortified by the fact that I'm calling for an agent to make the fact. So much we can take advantage of that issue. Saying here, look at the situation, this company.
They have conducted the meeting only now.
Only now, and they filed it. Therefore, he's a shareholder. He votes 10%, 11%. Others are there. Let us assume not I've done anything wrong. How does it help him by stopping me from filing what I consider to be correct filing to be done? He takes advantage of that argument. He may get relief, he may not get relief. I will justify as to what that filing was, what the mistake was, and how we corrected the mistake thereafter. And today, please see the situation. Not he is a legal. He replied to that legal. That legal. He did not understand. I have it with me. So we don't use it for you. That is my allegation. Now, of course, my reference is that is also not received. That is also all right. But how can you stop an AGM? How can you stop the outcome of the AGM? You take full advantage of the fact that I had issued one form at that time, another form now, all are wrong, all that stands to benefit from an argument of operation is such. Now, of course, every single thing when a company is functioning, my humble submission is very meaningful. It shows not, if I may say so, nothing but an intention to derail. Somehow finally get derailed because all you want ultimately is money. You want to force the majority to buy you up, to make payment to you. So you keep bringing in the majority as far as possible, where they get frustrated. This is nothing but an intention to do that. Humble submission. This AGM, let it go on. He will ultimately possibly succeed. I will justify as to what the earlier form was, what has happened, and how this new form is. I will justify.
My lord, may I just point out page 215 to negate the submission made by SARFAESI. I would like to seek 215. This is an email by the statutory auditor, the respondent number 9. He himself says, I am unaware of the details appearing in the NCA website, as also how the date of the last balance sheet is mentioned as 31/3/21, and how the MCA portal.
So that is what the learned senior counsel is saying. If the holding of the meeting would prove or justify your allegations, then let it be so.
That would be fine, but in the company petition, they have conclusively stated, yes, we held the agent who did not attend.
All right.
So therefore, by law, we may only state, let the any resolution passed in the agent, let it be subject to the outcome of the final decision of the NCLT.
You are already before the NCLT. Yes.
NCLT has not.
And you have raised this contention also.
So my lord, we only then direct the NCLT to expeditiously hear my application at least.
Perkal.
In fact, the NCLT is adjourned to matter 30th November. Since there is no sitting here, there is only a technical member who sits here.
The petitioners were earlier before this court in WP number 21644 of 2023. seeking aggrieved of a meeting notice dated 2/9/2023 in the matter of appointment of chartered accountants to the respondent company. So, learned counsel for the petitioner submits that in the presented petition, the petitioners are aggrieved of the impugned meeting notice at annexure AC dated 25/9/2023 to hold annual general meeting of the shareholders of the respondent company to receive, consider and adopt the audited financial statements of the company for the year ending 31st of March 2021, including the audited balance sheet as on 31st of March 2021, etc. So, learned counsel submits that the respondent company has already made a submission before the NCLT.
Petitioners have made submission to the
The respondent company has made a submission before the NCLT that a meeting for consideration of the audited financial statements of the company of the year ending 31st of March 2021 were already held on 29/10/2021, and therefore the impugned meeting notice could not have been issued. Stop. On the other hand, since an objection was raised at the hands of the petitioners before the NCLT, stating no such meeting was held, by issuing the impugned meeting notice, the contention of the petitioners is fortified. Stop. Next para. For contra, learned senior counsel Shri Dhyan Chinnappa, appearing for the respondent company, would submit that even if the respondent company has admitted before the NCLT that such a meeting was earlier held in the year 2021 and the respondent company cannot be prevented from holding the meeting for approval of the audited financial statements. Stop. On the other hand, if the holding of the elections for approving and adopting the audited financial statements of the year 2021 meeting for the year 2021 would fortify the objections raised by the petitioner, then it is for the respondent company to justify as to why a second meeting was required to be held and under what circumstances. Full stop. At any rate, it is submitted that since the meeting is scheduled to be held on 18th of October 2023 and the parties are already before the NCLT, the respondent company may be permitted to hold the meeting subject to whatever objections the petitioners may want to raise before the NCLT in the matter of the respondent company holding the meeting for adopting and approving the financial statements of the year 2021. Full stop. Next paragraph. Having heard the learned counsels and on perusing the petition papers, this court is of the considered opinion that the respondent company may go ahead with the meeting scheduled to be held on 18th of October 2023 in the matter of approval and adoption of the financial statements of the year 2021, subject to the petitioners bringing the same to the notice of the NCLT with the objections already raised by the petitioners that such a meeting was never held in the year 2021. Full stop. It is for the NCLT to decide the matter on merits. Full stop. Ordered accordingly.
Those objections are already to the NCLT and Section 88 all they may be directed to expeditiously hear these applications. So no application but now this order is challenged. Why is the NCLT has placed those objections before on 5th October it's been placed before the NCLT. 6th October they said we would have that taken on 30th November. Therefore,
next para. If the petitioners have already filed any application before the NCLT as regards the respondent company not holding the annual general meeting for approval and adoption of the financial statements of
applications to stop the meeting.
No.
If they file now, it's to stop the meeting being held on the 18th. This is why they came to your lordship. Now not to say that hold the meeting and then there is one other application which is to conduct an investigation at the company. Finding it that we decided step. 18.
What interim order can be passed?
Order was sought from the NCLT.
No, by them holding the meeting now,
Please.
and your objections would be justified that they had never held the meeting, such a meeting in the year 2021.
Say, I want to please be kindly enough to direct the NCLT consider the company petition expedition without.
We do not know what are the yes. What order? Which order?
what they are doing, they purchase not that recycle it. And my lord, in that they are not this was permitted. Next year, he is also God and police department.
Ah.
And in 99,
Ah.
there was one problem.
Ah.
And they have to be order passed by the Provisional, and they have to pay 20.
Ian, what do you want? You want it to be given to you?
Yes. No, no.
That will be, sir, these are all orders or proceedings that were held prior to the Transparency Act. Now, once the Transparency Act has come into force, all these things are not possible.
99.
That is why they have called for a tender now. You participate in the tender. You please participate in the tender, sir. Yes.
Is only calling rate contract, rate treatment. Not in fact, you have to kindly.
ಅದೇ ಆಹ್ವಾನಿಸಲು ದರ ಆಹ್ವಾನಿಸಲು ಕುರಿತು ಹೌದು
ಈಗ election.
that will be in terms of the Transparency Act, sir. It cannot be given to you just like that. ಮುಂಚೆ ಎಲ್ಲ ಮಾಡ್ತಾ ಇರಲ್ಲ ಆ ತರ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಈಗ.
ಅದಕ್ಕೆ kindly election, L will not pay 39. The proposal was for the respondent has sent a proposal to finance department.
Ah.
Election L.
ಹಾ
Election L at pay 39.
ಹಾ
Finance department has approved. And the first respondent
ಹಾ
had issued direction
ಹಾ
to the second respondent.
ಹಾ ಏನಂತ?
In terms of this, we go to the.
No, please read it. Please read it, sir. Please read annexure L. ಆ ತರ ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ. ಓದಿ.
LA
Ah.
39.
Yes.
ಪ್ರಸ್ತಾವನೆ ಪ್ರತಿಸಲಾಗಿದೆ. ಸರ್ಕಾರದ ವಿವಿಧ ಇಲಾಖೆಗಳಲ್ಲಿ ಸುಮಾರು ಪ್ರಬಲ ಅತಿಥಿಗಾರ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ಅನುಪಯುಕ್ತ ದಯವಿಟ್ಟು ಮತ್ತು ವೆಚ್ಚದ ವೆಚ್ಚವನ್ನು ಭಾರತ ವ್ಯವಸಾಯ ಉತ್ಪನ್ನ ಮತ್ತು ಸರ್ಕಾರ ಇವರಿಗೆ ಪ್ರಸ್ತುತ RTO ನಿಗದಿಪಡಿಸಿದ ದರಕ್ಕಿಂತ ಶೇಕಡಾ 25% ಹೆಚ್ಚಿನ ದರಕ್ಕೆ ಸಿಗುವ ಪ್ರಸ್ತಾವನೆಗೆ ಆರ್ಥಿಕ ಇಲಾಖೆ ಸಹಮತಿಸಿದೆ. So is given and I am ready to pay extra.
How this kind of a private negotiation is not permissible, sir. Once a Transparency Act is in place, this kind of private negotiation is not permissible. Why it should be given to you only? Why it should be given to you only? What is your special right, sir? ನಿಮ್ಮಂತವರು ಬಹಳ ಜನ ಇರ್ಬೋದು. So the state government has to call for a tender. If you are the person who quotes the highest price, you will be given the awarded the tender. Now, once the Transparency Act has come into force, the government organization and all other organizations are bound by the provisions of the Transparency Act. This kind of a private negotiation is not permissible. No. ಅದೇ ನಿಮ್ ತರದ ನೀವು sir, that will be contrary to Article 14 of the Constitution, sir. Your prayer is contrary to the Article of 14. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, those are all proceedings that are taken place before the Transparency Act. 1999 ಅಲ್ಲಿ Transparency Act has come into force.
And there is one more article. Next year.
Learned AGA takes notice for both the respondents. Next para. The petitioner, an association, is before this court seeking a direction to the second respondent, State Hospitality Organization, to dispose of old tires. ಏನೇನು ಬೇರೆ old tires and tubes and vehicle spare parts to the petitioner association, while quashing the impugned invitation for expressing the rates from the general public. Stop. Next para. Learned counsel for the petitioner submits that earlier to the disposal of such old tires, tubes, and spare parts were made to the petitioner association, having regard to the fact that the petitioner association belongs to the downtrodden section of the society. Downtrodden and the weaker section of the society. Full stop. The learned counsel has also here is where is the from where did we get this annexure L? Young siktu nimgidu. This is not a communication. Then how did you get this? Learned counsel submits that a representation was given by the petitioner association on 5/6/2023 at annexure K to the minister for housing, Waqf and minorities, and the concerned minister had recommended the representation given by the petitioner association to the finance department, and the finance department had taken a decision that the material can be disposed of to the petitioner association at the rate of 25% more than the rate fixed by the RTO. We'll stop. Next paragraph. In the considered opinion of this court, the issuance of the impugned notice would be in compliance of the requirement of the Karnataka Transparency in Public Procurement Act, 1999. We'll stop. Clear?
From the public.
No. It is not only for buying, even for disposal it applies. No, sorry, sir.
Not buying. Therefore, Act is not.
It cannot be so narrowly construed, sir. It applies to all transactions of the government, whether it is buying or selling. The word procurement would indicate both. It cannot be only for buying. The provisions contained in the Transparency Act, more particularly Section 5, prohibits any procurement at the hands of the state government and its agencies without following the provisions of the said act and by inviting tenders. Stop. in the considered opinion of this court, Annexure A would be in compliance of the provisions of the Transparency Act, and therefore no fault can be found in the impugned notice. Full stop. The next para, the petitioner association is free to participate in the auction or submit its rates. And if the rates are acceptable by the second respondent, the second respondent may proceed to pass orders in accordance with law. Clear. Recreation. All right.
Engineering, bill number 19, Dakota Street.
Yes.
Some margin problems. Not up to date. The essential command dispute is really some hard orders. Said you brought up a notice in Commissioner of Friendship Supply as per our mentioned email. And Commissioner also informed the respondent 1 and 2. The problem in the state. In similar matter, you watch already disposed them.
Huh? How is this order going to help you? He has passed an order. ಅದರಲ್ಲಿ
you approach the appellate authority and then ಮಾಡಿದ್ದಾರೆ. Is the appellate authority as per annexure F penalty? Is the appellate authority? He has to decide the matter instead of deciding the matter.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
ಇದರಲ್ಲಿ you approach the appellate authority ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
Annexure A ಮೇಲೆ. Last time.
Yes.
Last time.
Yes.
29/7/2000 ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಮೊದಲನೇ ಸಲ್ಲಿಸಲಿ ಇದ್ದ ಆರೋಪ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಪುನರ್ಕಷವಾಗಿ ಮೇಲ್ಮನಿದಾರರ ವಿರುದ್ಧ ಜಿಲ್ಲಾಧಿಕಾರಿ ಶಿವಮೊಗ್ಗ ಇವರೇ ನಿಯಮ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಕಾನೂನು ಆದೇಶ ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ಮತ್ತು ಮೇಲ್ಮನಿ ಪ್ರಾಧಿಕಾರ ಇವರು ನ್ಯಾಯಾಲಯ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಹಾಗೂ ನೈಸರ್ಗಿಕ ನ್ಯಾಯಾಲಯದ ವಿರುದ್ಧವಾಗಿರುವುದರಿಂದ ಮುಂದಿನ ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರವನ್ನು ಸಂಪರ್ಕಿಸಲು ಸೂಚಿಸಿದ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆ ಅಂತ ಕೇಳ್ತಾರೆ. ಇದರ ಅಪರೇಟ್ ಅಂದ್ರೆ ಸಾಹೇಬ್ ಸಬ್ಜೆಕ್ಟ್ 40,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವೇ ಬ್ಯಾಚ್ ಆಫ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ವಿ. 2 ಉಟ್ಕಟ್ಟಿದ್ದಾವೆ, ಇನ್ನೊಂದು ಬರ್ತಿತ್ತು.
ಇಲ್ಲ, ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಆರ್ಡರ್ ಎಸ್ at annexure B is there. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇತ್ತು. Joint director order is there at annexure B. Other mele they had gone before the deputy commissioner. Deputy commissioner has passed this order at annexure A, saying the entire proceedings were initiated at my instance, and it would not be proper for me to hear the matter. Go before the higher authority. Same thing has been considered here in this matter. We have said it does not lie in the mouth of the deputy commissioner to say that the action was initiated against the petitioner society as per his direction, and therefore he would not be competent to hear the appeal. Initiation of action may have been at the directions of the deputy commissioner, but that does not preclude the appellate authority to consider an appeal on merits and dispose of the same in accordance with law. We have directed him to consider and pass orders. Same thing applies. Perfect. The 2021 September ಫೈಲ್ ಮಾಡಿರೋದು ಇದುವರೆಗೂ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ಯಾವಾಗ? ಹಾ? ಇದರಲ್ಲಿ ಏನು ಸುಮ್ಮನೆ ಎಜಿ ಅಂತ ತೋರಿಸ್ತಾರೆ. Learned counsel for the petitioner submits that when the petitioner approached the first respondent deputy commissioner, appellate authority, questioning the orders passed by the joint director, the deputy commissioner has held that the action were initiated against the petitioner at his instance, and therefore it would not be right on his part to hear the appeal. Stop. The deputy commissioner therefore directed the petitioner to approach the higher authority. Stop. Learned counsel submits that this court has considered similar such contentions in the case of R. Manjunath versus the deputy commissioner and another in WP number 16976 of 2021, dated 16th of December 2022. Stop. Next para. It's clear from the said order that this court has held that it does not lie in the mouth of the deputy commissioner to say that the action was initiated against the petitioner society, as per his direction, and therefore, he could not be competent to hear the appeal. Stop. This court therefore directed that initiation of the action may have been at the directions of the deputy commissioner, but that does not preclude the appellate authority to consider an appeal on merits and dispose of the same in accordance with law. Stop. The petitioner is entitled for similar relief. Full stop. Next para. Consequently, the writ petition is allowed. The impugned order dated 11th of August 2021 at Annexure A, passed by the first respondent deputy commissioner, Shivamogga, is hereby quashed and set aside. So the matter stands remanded back to the deputy commissioner, Shivamogga district, to consider the appeal in CR 12 of 2021-22 on merits and in accordance with law. Stop. So, ಮಿಕ್ಕಿದೆಲ್ಲ ಹೆಂಗಿದೆ ಹಂಗೆ ಹಾಕ್ಬಿಡೋಣ. Yes. ಇಲ್ಲ. Correct. The amount deposited by the petitioner before this court is directed to be returned to the petitioner. Return ಅಂದ್ರೆ ಏನು?
GPI. Register my complaint. Initially, this what pertains to a fraud. Money bank officials that will be just by Canada Bank. Each each 1
To writ of mandamus directing the respondent CBI to register an FIR based on the written information.
Lord emanates from a joint development agreement entered into between the petitioner and his mother, the developer. As per the state agreement, Lord agreement dated 3/9/2012. It's a residential apartment. 74 flats paid to the share of the owner and 94 flats to the builder. The petitioner Lord is the owner of the land along with his mother. Subsequently, a supplementary agreement dated 22/1/2014 was entered in, whereby Lord the builder tells the petitioner and his mother that out of 74 flats, please transfer 25 flats to me. That is, held 25 flats to me. And for that purpose, they decide to open one exclusive account with the Canada Bank. Then it was specifically agreed that the petitioner and mother would be the joint signatories and they would operate the account. What they would do is in connivance with the bank manager of the Canada Bank particular branch. On the particular day when they visit, they take signatures of the mother of the petitioner on printed plan form, and that is misused by the builder, and it has been converted into a joint account, and the builder has misappropriated funds to the tune of 14 crores. This being a public sector bank and any fraud above 1 crore will have to be investigated by the CBI as per the RBI circular. Next, we approach the CBI, they have not. In fact, there is an interim order passed by the Honorable Court of 28/2023 directing the CBI to place on record the records that leads to the aberment in para 4 of the statement of objection by next date. In their statement of objections, they say that a discrete verification was conducted. That is not permissible as per the constitution-based judgment in Lalita Kumari. They were supposed to
Yes.
file the base the record.
At the request of the learned counsel for the respondent, CBI released this matter on 26th of October 2023 to enable the respondent to comply with the directions issued by this court on 28/3/2023. Yes. We are directed you to file statement.
For the year 2015 up to the year 2011. Has paid price amount of 6 lakh. His claim with regard to the price amount for the year 2013 is pending. Sir. And he is writing around the document. But on account of the consent officer was not available. For the year 2015.
Release this matter on 30th of October 2023. We'll stop. In the meanwhile, the respondents may either file statement objections or an affidavit, meeting the averments of the petitioner, and whether any steps are taken in that regard, in regard to the representation given by the petitioner. ಅದ ಈಗ ನೀವ್ ಹೇಳಿದ್ರಲ್ಲ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಕೊಡೋದಿದೆ ಅನ್ಬಿಟ್ಟು ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ ಪ್ಲೀಸ್. ಎಸ್. Yes.
I have repaid the entire loan notes in respect of first.
Yes. What are the instructions?
Now I have given pay number 3. Now one bank guarantee is now outstanding.
So you are contesting the submissions made by the petitioner. You are contesting the submissions made by the petitioner. ಗೊತ್ತಾಯ್ತು. But the same property has been given as a mortgage to in respect to other accounts. Yes.
I am ready to close that also. That's what I just.
ಮಾಡಿ.
If that is.
It will be released.
That is closed, they are ready to release notes. As per para 3, page 3 notes, the filed by my learned friend. That's petitioner number 2, Ranganatha Enterprises, petitioner number 3, Sai Filling and the Eredic. Here petitioner number 2 and 3. But your lordship's notes permit me to close those loans within 4 weeks. With that directions notes, it can be disposed of. I'll close those loans. Subject to notes, let them be directed to release the original documents.
Paragraph number 3, na?
Page 3 notes.
Page 3.
Petitioner number 2, Ranganath Enterprises, so they say notes outstanding is 1,83 lakhs. Petitioner number 3, there is no due. Those 2 notes, so 1,83,000 notes. The direct liabilities notes, I undertake to notes clear within 4 weeks. I may permit it to clear within 4 weeks. Subject to notes which they can release the original documents.
Personal guarantee of Mr. M.K. Shashikant, 732 lakhs.
Another loan I got that is started with MJ and he is the director. Shashikant doing the proceeding all the
That they cannot clear. That I am saying is, I am no more the director, I already resigned.
Blue Cliff Apparels.
ಅಲ್ಲಿ ಯಾವುದೂ ಸೆಕ್ಯೂರಿಟಿ ಕೊಟ್ಟಿದ್ದಿಲ್ಲ, ಅಲ್ಲಿ ಪರ್ಸನಲ್ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟಿದ್ದು. And before the account was declared as NPA, I have already resigned and come out. So therefore, what I am now submitting is petitioner 2 and 3, who are the petitioners in this case. Any liability notes I'll clear. Subject to that notes, the originals may be released.
In accordance with law, in accordance with the provisions of the Companies Act, if he has come out of the company,
Not accepted. Because at the time of gratitude, you were there.
who has not accepted?
Bank, you are given the letter, interest for case in impact banks, and not the case. Because at the time of gratitude, you were there. Now that you have been the entire thing and you are going out.
Before it could classified as NPA, 1 year before it was classified as NPA, I have already resigned. And
No, that is why I'm saying, in accordance with the provisions contained in the Companies Act, if he has gone out of the company and has been registered in the register of the register of companies, you cannot say no, he continues to be liable. It is only in accordance with law that you can do. Arbitrary ಬೇರೆ ಯಾವುದು ಇಲ್ವಲ್ಲ.
Arbitrary ಬೇರೆ. ಇದು ಒಂದಿದೆ that I undertake to pay within 4 weeks.
ಎಷ್ಟು ಅಮೌಂಟ್ ಅದು?
1,83 lakhs. Para 6 first line.
All right.
That I will undertake.
Learned the petitioner, the petitioners more particularly Sri M.K. Shashikant, who is said to be the managing director of petitioner number 1 company and proprietor of petitioners number 2 and 3, is before this court seeking a direction to response number 2 and 3 Canara Bank to release the original documents tendered by the petitioner as collateral security for several loans obtained at the hands of the respondent bank. So, on the previous occasion, the learned counsel for the petitioner had submitted that the petitioner has tendered as cleared all the loan obtained by the petitioner from the respondent Canara Bank.
Petitioner 1 has cleared.
Petitioner number 1 has cleared all the loans obtained by petitioner number 1 from the respondent Canara Bank, and therefore the prayer to direct the respondent bank to return the original documents. Full stop. Learned counsel for the respondent bank was directed to secure instructions and make submissions. Full stop. ಇದು ಫೈಲ್ ಮಾಡಿದೀರಾ? Next para. Learned counsel for the respondent Canara Bank submits on instructions that no doubt petitioner number 1 has paid the outstanding amount of rupees 8 crores 25 lakhs as on 30/7/2023 after obtaining loan from
I say.
the fourth respondent ICICI Home Finance Limited. Stop. However, the said Sri MK Shashikant is also the proprietor of petitioner number 2, Messrs. Ranganatha Enterprises, on whom there is an outstanding loan amount of rupees 1,83,01,163 to be paid along with interest, and the said person is also the director of Messrs. Blue Cliff Apparels India Private Limited, where there is an outstanding loan amount of rupees 732.03 lakhs. Stop. Learned counsel for the petitioner submits that the petitioner, Sri MK Shashikant, is no more a director in the said company as on
1st November 2021.
1st of November 2021.
21 is resigned.
Stop. Learned counsel submits that in terms of the provisions of the Companies Act, the petitioner has come out of the company, and therefore there cannot be any liability on the petitioner insofar as the loan obtained by Messrs. Blue Cliff Apparels India Private Limited. Stop. Next para. Having regard to the submissions made by the learned counsel for the petitioner as well as the learned counsel for the respondent Canara Bank, this court is of the considered opinion that if the petitioner clears all the outstanding loan amount in respect of the 3 petitioners are concerned, then the second and third respondent Canara Bank is bound to release the original documents which were tendered by the petitioner as collateral security for the loan obtained by the petitioners. Full stop. The question of the petitioner, Sri MK Shashikant, being held responsible and liable as a personal guarantor insofar as Messrs. Blue Cliff Apparels India Private Limited is concerned, the respondent Canara Bank has not secured the immovable properties belonging to the petitioner.
1 to 3. Petitioners
1 to 3, insofar as the loan obtained by the said company, and it's only a personal guarantee. Full stop. If the petitioner has come out of the said company in accordance with law and the same is registered with the registrar of companies, the respondent Canara Bank cannot hold back the original title deeds tendered by the petitioner for the loan obtained by the petitioners. Full stop. Next para. Consequently, the writ petition stands disposed of, granting liberty to the petitioners to clear all the outstanding loan amount in the account of the petitioners with the respondent Canara Bank.
in respect of petitioners 1 to 3 hearing.
Petitioners number 1 to 3. Full stop. If the loan amounts as indicated by the respondent Canara Bank in respect of petitioners number 1 to 3 is cleared by the petitioners, comma, the respondent Canara Bank shall return all the original title deeds tendered by the petitioners with the said bank and shall not insist that the same will be kept pending in the matter of the loan obtained by Messrs. Blue Cliff Apparels India Private Limited. We'll stop. Next para. Ordered accordingly.
Sir, kindly observe. Within 4 weeks, I shall clear it.
As and when you do it,
Very, very. I'm applying.
Submission. 65. More than ನಿನ್ನೆ ಬರ್ಬೇಕಾಗಿತ್ತು, ಬರ್ಲಿಲ್ಲ. ನಿನ್ನೆ ಬೆಳಿಗ್ಗೆ ಬರ್ಲಿ, ಇವತ್ತು date ಇದೆ, ನೋಡ್ಬಿಟ್ಟೆ ಬಂದಿಲ್ಲ. Petition ಇದು ಏನಾಗಿದೆ ಅಂತ
ಇವಾಗ ಏನ್ ಮಾಡ್ಬೋದು? Please wait.
End of the day, my lord. End of the day.
Sir.
Wait again.
ಕೊಟ್ಟಲ್ಲ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಅಲ್ಲ ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ ಇವತ್ತು ನನ್ನ ರಾತ್ರಿ ನೋಡಿ ಬೆಳಿಗ್ಗೆ ನಾಳೆ ಫುಲ್ ಶುಕ್ರವಾರ ಬೆಂಚ್ ಅಲ್ಲ ಇನ್ನೊಂದು ಬುಧವಾರ ಬರ್ಬೇಕಾಗಿತ್ತು ಬುಧವಾರ ಹೋಗ ಬಂದಿರೋ ಒಂದ್ ಎರಡೆರಡು ಬಂದಿದ್ದು ಮುಗಿದೋಗಿರ್ಬೋದು ಯಾವುದು ಸುಮ್ಮನೆ ಹೇಳೋರ ನಿಮ್ಗೆ ಮುಂಚೆ ಗೊತ್ತಿದ್ರೆ ಸ್ವಲ್ಪ ಆಗಿದೆ ಮತ್ತೆ
ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಆಗಲ್ಲ ಅಂದ್ರೆ ಎರಡೆರಡು ಮೆಮೊ ಹಾಕಿದೀರಾ, ಅದಕ್ಕೆ ಒಂದ್ ಕಳ್ಸಿದೀನಿ, ಒಂದ್ ಇಲ್ಲಿ ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳಿ. ಆಗಿತ್ತ ಬಂದ್ 15 ಕೇಳ್ತಾ ಇದ್ರೆ ಎಷ್ಟು ಅಂತ ಹೇಳೋದು? ಕಳ್ಸಿರೋ ನಾನು ಬಂದು ಎತ್ತಿಟ್ಟಿದ್ದೀನಲ್ಲ, ನಾನೇ ಕಳ್ಸಿದೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ರೆ ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದಾರೋ ಅವ್ರು ಬರಕ್ಕೆ ಸರಿನಾ? ಇನ್ನೇನು ಹೇಳಕ್ ಎರಡು ಡೆಮೋ ಹಾಕಿದ್ದೀರಾ, ಸೇಮ್ ಪಾರ್ಟ್ ಸೇಮ್ ನಂಬರ್ ಎರಡು, ಒಂದ್ ಎತ್ತಿಟ್ಟಿದ್ದೀನಿ, ಒಂದ್ ಕಳ್ಸಿದ್ದೀನಿ. ಕಂಡೀಷನ್ ಮಾಡಿ ಹೇಳಿ ಮೆಸೇಜ್ ಮಾಡಿದ್ರಲ್ಲ.
ಇವ್ರು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹೌದು, ನಾನು ಕೂಡ
Okay, I'll get checked.
United States patent and trademark office committed breach of patent cooperation under the article 1901 on 5/8/2015.
What are you trying to, what are you trying to submit now?
And just one minute, I'm just making this.
What, sir?
8 years since the breach of patent cooperation. And over 4 years since the complete worldwide liability for my patent right was. The point is to issue the consent letter. And this repetition is now 4 months.
We have directed them to file statement of objections,
You know,
isn't it? Then
now I take it particularly before the vacation. Next week is vacation. I have presented the documented evidence. I need interim orders. If respondent files any objections, I will argue to those objections.
no,
I need interim orders before the vacation, you know.
no, sir.
It is. it's really
No,
important
not
because I have
possible.
there's legal urgency for other.
Not possible, sir. Yes,
As a party in person, I need a hearing date, you know. Can I post it for 25 or 26?
I have given 2 or 3 weeks time to them to file statement of objections. It means it will come after vacations only, not before vacation. Yes.
So on which date is my hearing date?
No, they know the, because the roster will change. I am not going to give a date. The learned judge who comes and occupies this chair, he will give the date. Yes.
Application for litigation rights pending from July.
Huh?
Application for litigation rights are pending from July.
Move in the morning, tomorrow morning. Yes. Huh? 27. Senate Council for Petitioner has filed a memo dated 10/10/2023 stating that a dispute has been settled between the parties before the National Lok Adalat in the original suit, and therefore the petitioner does not press this writ petition. Will stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the petition stands dismissed as withdrawn. Yes.
And maybe I have to make one submission. Because yesterday afternoon I made a submission and my lawyer directed me to file a memo in the morning, file a memo in the morning. I come down from Chennai for 2 days. The urgent matter, I need an interim relief in a finance institute taking possession of.
Which matter?
Record number 232.
Huh? You have moved a memo in the morning.
I sent a memo in the
Ah.
morning, not just the afternoon. I read back.
Afternoon. I have not directed them to list it in the afternoon.
It
will come up tomorrow. Yes.
The announcement of event.
Yes.
Petitioners are Australia. So he's on parole.
41.
41.
Ah.
70 is more than parole.
Ah.
Agency.
No. Without hearing the other side, no orders can be passed. ಅವ್ರಿಗೆ ಇನ್ನು ನೋಟಿಸ್ ತಗೋಬೇಕು, ಅವರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋಬೇಕು. ನೋಡೋಣ, let us see. Yes. ನೋಡೋಣ, let us see.
Bill number 66. Your Honor, exceed.
For the reason stated above, this court is of the considered opinion that there is no merit in the writ petition. Consequently, the writ petition stands dismissed.
Approved matter. Number 2, Ramesh K. Was working as the secretary of the VSSN from 68 to 2008. Now he retired. During his tenure of office, he has distributed the essential commodities for distribution of his order. So they have distributed it, in time and remitted the amount to the society's account. From society, no complaints whatsoever. But some private person had filed a complaint, a private complaint stating that the petitioner herein has misappropriated the commodities listed. Based on that, a charge sheet is filed. The matter is pending before the magistrate. Now, the deputy commissioner had issued a so-called notice in their proposal day, calling upon the against the petitioner herein in the capacity of secretary.
2008.
2008.
Huh.
All the records are seized in the criminal case. Now, the deputy commissioner has passed an order stating that you have misappropriated to the tune of 5,90,000 to remit it to the account or its criminal case initiated against.
It's already initiated against you.
Initiate either initiate by the government. The Procedural candidate goes the order and it is given. This insofar as the VSS is concerned, amount is remitted, it has no remit. Operating portion below. In the capacity of the secretary has distributed it and remitted it to the account. Now, in my individual capacity, the included order is passed. So, notice. The operating portion of the 51 to 50. Misappropriation amount is credited to the VSSN account as and when the essential commodities are sold. Now, we also Annexure B, a notice was issued.
Annexure G is a finding going against the society also.
ಇಲ್ಲ ವರ್ಷಕ್ಕೆ ಪ್ರತಿವಾದ ನಂದನ್ ಮಾಡ್ಯಾರ ನಾರಾಯಣ ಸೊಸೈಟಿ ಅವರು ಗ್ರಿವೆನ್ಸ್ ಎಲ್ಲ ಇಟ್ ಅಮೌಂಟ್ ಇಸ್ ಕ್ರೆಡಿಟೆಡ್ ಮಾಡೋದು
ಸರಿ
ಅದನ್ನ ಇವಾಗ ಎಕ್ಸ್ಪ್ಲೇಷನ್ ಕೇಳೋದಾದ್ರೆ ಅವ್ರು ಸೊಸೈಟಿ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕು even otherwise society has no grievance against me. I am retired from the service. In the private company, a criminal case is already registered. Now, once again, an order is passed. You have misappropriated to the tune of 5,90,000. There is no basis for this. All the records related to this issue is seized in a criminal case. So, the individual capacity is not.
ಸರ್ ಸೊಸೈಟಿ ಅಂತಂದ್ರೆ ಇಟ್ಕೆ ಯಾರಾದ್ರೂ ಏನಾದ್ರು ಮಾಡಿದಾರೆ ಅಂತಂದ್ರೆ ಸಮ್ಮನ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಸೊಸೈಟಿ ಓನ್ಲಿ ವಿಲ್ ಡು ಸೊಸೈಟಿ ಅಂತ ಹೆಸರಿಟ್ಬಿಟ್ಟು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಎಸ್ ಕರೆಕ್ಟ್.
The society says, I have not deposited the amount,
Yes, what do you say? No, no, what is the material available on record? He says there is no such material. Show cause notice Allah. What is the material? That cannot be material. If there is no material on the basis of which the order is passed, then the learned counsel is right in his submission. In the impugned order, if it is not, does not reflect to collection of any evidence, learned AG takes notice for response number 1 to 4. Issue emergent notice to respond number 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. We'll stop. Next paragraph. Learned counsel for the petitioner submits that the petitioner was working as a secretary in the fifth respondent society and he attained the age of superannuation on year of the when did he retire? Yeah, for all relevant information you don't collect. Huh? Please collect that. 15 ಆಯ್ತಲ್ಲ. But if that information is not correct, then it is difficult. Attained the age of superannuation more than 15 years ago. Stop. However, proceedings were initiated against the petitioner in the year 2007-2008 in respect of certain allegations made against the petitioner that he had defaulted in remitting certain amounts to the tune of rupees 5,99,869, in respect of transactions that took place in the year 2008. We stop. Learned counsel submits that a criminal proceedings are also initiated against the petitioner. We stop. Learned counsel submits that the impugned order dated 15/2/2023 at Annexure G has been passed by the second respondent deputy commissioner, holding the petitioner liable for the loss accrued to the fifth respondent society, and the petitioner has been directed to remit the entire sum of rupees 5,99,869 within a period of 90 days from the date of the order. We stop. Learned counsel submits that there is no basis for the conclusion drawn by the deputy commissioner, since no material was available before the deputy commissioner, as the entire original records are lying with the police or before the learned magistrate in the criminal proceedings. We'll stop. Next paragraph. Accepting the submission of the learned counsel for petitioner, comma, there shall be an interim order of stay of the impugned order dated so and so at annexure so and so, comma, till the next date of hearing.
Number 23, orders. One day in. It's an all respondents is
Complete, huh?
Yes, point number 9 has been answered.
Amma? ಒಂದೇ ಒಂದ ಯಾವುದು?
ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಸರ್ವಾಗಿ ಬಂದಿದೆ, ಡಿಟೇಲ್ ಲೆಟರ್ ಎಲ್ಲ ಬಂದಿದೆ.
But it appears that in the note, officer said that 9 is unserved. 4, 9 and 13 was supposed to be answered. We have filed a memo that even 9 has been served, copy has been received by 9. Steps to be taken in respect of unserved R9 K Nagesh.
ಇದು 5, 6, 8, 11, 12, 14 ಏನಾಯ್ತು?
All are served. According to the office report, it's it is all delivered. Only 9. It was stated that he is unserved because unserved cover returned with postal shara. But the hand summons that your lordship directed on R9 has been received.
Where is the hand summons?
That is filed. Acknowledgement is filed
ಯಾವಾಗ?
on 8 September 23.
Learned senior counsel Sri Vivek Subbareddy, appearing for the petitioner, submits that even according to the office,
Yes.
all the respondents have been served except respondent number 9. Full stop. Insofar as respondent number 9 is concerned, comma, the learned senior counsel would submit that the hand summons have been served on the said respondent.
Yes.
And the hand summons have been filed in the office. Idyanamma?
But notice ಕಳಿಸಿ ರಿಟರ್ನ್ ಬಂದಿದೆ.
It's 2 of the memo.
Next para, on going through the hand summons, comma, it is clear that the 9th respondent has received the notice on 4/9/2023. Full stop. Therefore, service is complete.
Statement of objections had to be filed by them.
Yes.
It was today.
Any other learned counsels appearing for any other party? You ಮುಂಚೆನೆ ಬಂದಿದ್ರಲ್ವಾ? It has been noticed. However, at the request of the learned counsel for the respondents,
State ಕೊಟ್ಟಿದ್ದು ಇವತ್ತೇನೆ. They had not filed. 8 weeks.
ಅಲ್ಲ ಅವರು ಇದಾರೆ, ಆಮೇಲೆ ಬೇರೆಯವರು ಇದಾರಲ್ಲ ಹೊಸದಾಗಿ ಬಂದವರು, ಆಮೇಲೆ ಅದನ್ನೇ ನೋಡ್ಕೊಂಡು ನಾವು we said anyway time has to be given to them. Finally, 3 more weeks time is granted at the request of the learned counsel for the respondents to file statement of objections. We'll stop. Release this matter on 18th of November.
Earlier.
I'm going to Kalburgi.
Video at least.
Bada bada. I will be here on 18th. That is why I've given that.
Finally.
ಹೇಳಿದ್ನಲ್ಲ ಫೈನಲ್ ಇಂದ ಬಂದಿದೆ. Yes. Yes. Copies. ಕೊಡು. ಕೊಟ್ಬಿಡಿ ಅವ್ರು. Yes. Yes, yes. Yes.
Please. The respondent.
Huh?
The respondent. So,
Ah.
respondent.
Have
to be placed ex parte, at least next state, I think is what you could consider.
ಸರ್ವಿಸ್ ಇಸ್ ಕಂಪ್ಲೀಟ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು.
Services.
Yes.
ವಿಶ್ವನಾಥ್
On 5/10/2023, the following order was passed. Extracting. Matter is called out. There is no representation for the petitioner. Full stop. Consequently, the petition stands dismissed. Yes. Interim orders agide. Interim orders have been passed. Then let it come up after vacation.
There are 5 applications to restrain.
There are other parted matters, madam. You can't start it now. This is matter after Dasra vacations. Interim order granted earlier stands extended till the next date of the year. After vacation, non date kodak baradilla. Yes.
26 Anand M Salapur Mat. Amount has been paid and a note has been granted.
Yes. At the request of the learned counsel for respondent, release this matter on 13th of October.
So not a pass. 28 Sachin BS.
ಇವತ್ತು ಆಗೋದಿಲ್ಲ.
There's no urgency in this matter. A single reason. As per rule 48 of the Karnataka schools, a scheme of administration has to be implemented within 6 months from the date of implementation of the rules. In respect of this institution, the scheme has been implemented and election has been.
No, last time something else has been noticed, that there's an appeal provision.
Yes, there is an appeal, yes. Then 69(3).
Appeal provision I am not disputing, but this order is contrary to the violation of principles of natural justice. Natural justice. Statutorily, the hearing put order for review.
And the same submission can be made before them also.
That's
See, when this court has noticed that there is an appeal provision and granted time to you to make submissions on that provision, and you admit that yes, there is a alternative efficacious remedy, then nothing can be.
But hearing put to order statutorily the hearing put.
Sorry,
Well, alternate remedy is not a bar. There is an exception, two exception principle to the alternate remedy.
Yes.
One is if an order is passed without jurisdiction.
Yes.
And if an order is passed in violation of principles of natural justice. I fall within the category of second category. Where my lords alternate remedy is not a bar.
Who has passed the order?
But so kindly see, the order is passed by the Waqf authority. Straight away it contravenes the, my lords kindly see the statute. The statute says that, kindly see the statute.
Annexure A is the impugned order.
I draw my lord, yes, annexure A and B is the impugned order. My lords kindly see the statute, that is section.
Amendment. Amendment to the scheme of the administration.
ಅದರಲ್ಲಿ ಮುಂಚೆ ಆರ್ಡರ್ ಬರ್ತಿದ್ದಾರೆ ಹಿಯರಿಂಗ್ ಕೊಟ್ಟು ಬರೀರಿ ಅಂತ ಹೈಕೋರ್ಟ್ ಅವರು ಆರ್ಡರ್ ಬರ್ತಿದ್ದಾರೆ.
Hmm.
Again they violate when they pass an ex parte order. There is already direction by the High Court saying that you go strictly as per section 62 of the Work Act. They won't take the section 62 and again he passes an order.
Where is that?
Kindly see, I draw my lord's attention to, kindly see,
Where is the previous order?
previous, yes, please, my lords. The previous order, my lords would find it at page number 144. I was watching, my lords.
Yes,
I draw my lord's attention to page 146.
yes.
They want to bring the authority wants to bring the amendment to the scheme for which I have filed my objection. At that point of time, at page number 146, I filed a writ petition, para 4. At this stage, the writ petition would not call for any interference by this court. As under section 69 of fact, a final order has not yet been passed. The proceedings is still at the interim stage. Therefore, reserving liberty to the petitioner hearing to file the statement of objection to the said communication, writ petition would not call for any further direction and it is disposed of. Next page, kindly see. It is needless to observe that if any statement objection is filed by the petitioner hearing, the first respondent board shall consider the same in accordance with the in terms of section 69 of the Act, read with the rules made thereunder. Kindly point out this.
Yes.
In terms of section 69 of the Act, read with rules made thereunder.
Yes.
Now kindly see section 69.
What is work back? Yes.
I draw my lord's attention to section 69 subclause 1, which would be relevant to my case.
Yes.
Where the board is satisfied after an inquiry whether its own motion or an application of not less than 5% interested in any work to frame the scheme for proper administration of the work, it may by an order frame such scheme for administration of work after giving reasonable opportunity and after consultation with the mutawali or others in the prescribed manner. Now this section 69 subclause 1 is governed by rules. Kindly see rule 62 of Karnataka rules. Rule 62. Rule 62 of Karnataka Works Rules 2017.
Yes.
Yes. The board shall issue a notice in form number 52 to the mutawali concerned and to every person interested in work, and board shall also affix the said notice at a conspicuous place in the premises of work institution regarding the scheme of administration to be framed under subsection 1 of section 69. Next, subclause 2. The board shall examine the objections, suggestion to the scheme of administration received in response to the notice of subclause 1, may give an opportunity of being heard and accord approval to the scheme of administration with such modification as it deems fit. This is completely missing, subclause 2, for which there is no answer by the respondent in their statement of objection. They are not extended their granted, they are not extended the opportunity of hearing to the petitioner.
Yes, sir.
If they are able to answer me that, answer this court that there is an opportunity of hearing to the petitioner, straight away I don't have case.
Yes.
Implementing the scheme.
Yes.
For that, rules 48 of the Karnataka Work Rules. It says that. Let's see, rule 48.
Yes.
Of management. It is 6 months. On the date of commencement of this work, the above said and accept the outcome. Having their deed of work by the body shall fail the scheme of the management as prepared under clause B of subsection 2 of section 32 of the Act.
Yes, what do you say about the opportunity not being given to the petitioner?
It has been given. It has been given.
How is it?
Last minute, and this, they had filed objection.
Yes.
Annexure, M. They
Yes.
have- Then our opportunity has been given, that this thing was considered, and therefore the amendment was also made.
Where is it reflected?
That is,
Where are the objections reflected? How is it considered?
but here,
Perfect. Learned counsel for the petitioner submits that despite specific orders being passed by this court on an earlier occasion, in WP number 43317 of 2018, that if the petitioner files any objection to the scheme of administration and management of the work institution, the respondent board shall consider the same in accordance with law in terms of section 69 of the Act, read with rules thereunder, comma, the board has passed the impugned order at Annexure A without considering the objections or giving an opportunity of hearing to the petitioner. Stop. Learned counsel submits that Rule 62 of the Karnataka Work Rules 2017 clearly provides that the board shall examine the objections or suggestions to the scheme of administration received in response to the notice issued under sub-rule 1, comma, give opportunity of being heard and accord approval to the scheme of administration with such modifications as it may deem fit, comma, the impugned order has been passed in violation of the provisions as pointed out by the learned counsel for the petitioner. We'll stop.
this court's order is the.
Next para. Consequently, there shall be an interim order of stay of the impugned order at Annexure A, comma, till the next date of hearing.
Annexure A, there are two approval orders.
Huh?
There is an order passed by this honorable court, my lord.
Yes.
On 7th February of 2023, Annexure R1 I have provisional. There, my lord, the court said that, this honorable court said that there is no committee, there is no management committee. Then, my lord, the court has also observed that after the scheme, my lord, the election has been held. Election has been held, the election has been held, the managing committee is in power now. The managing committee has been elected. My lord, if at all they are agreed, my lord, they have to file my lord, appeal before the tribunal under section 69(3), my lord. My lord. Therefore, my lord, the question of granting an interim order to the staying the scheme, my lord, does not arise because of this order. So kindly read this order, my lord. I have published that Annexure R1. This honorable court has done. This honorable court has taken notice of this paragraph number 4, along with my statement of objection. I could not get this statement of objection.
Because election was challenged in those writ petition, and my lord's court has dismissed the said writ petition, which is nothing to do with the scheme of administration.
2019.
Yes.
2019 you're talking of.
No, 2023 one. 2008.
Annexure?
Annexure R1 to my statement of objection. 7th day of February 2023 one.
Appointment of an administrator.
Yes, appointment of an administrator for the purpose of holding an election. That was challenged before this honorable court, my lord. This honorable court has taken notice of the what transferred. Then, my lord, the subsequently the election is also the fresh election has been held. Now, question of my lord, the staying the scheme of administration, my lord, as per the scheme.
September 2022.
This honorable court declined to interfere with the election, with the appointment of the administrator for election. Paragraph number 4, my lord. In the indirect number, a new scheme of management. A new scheme of management of work was notified by the board in terms of power under section rule 48 of the Karnataka Work Rules. And the scheme of administration of work is dated 16/6/2022, which is the.
Where are you reading?
Paragraph number 4 of that order dated. The past and repetition number 1828 of 23.
Page number?
Page number 13, page number 13 of the statement of objection. Shall I give an?
Yes, yes, it is here. Page number?
Page 13, my lord, paragraph 4.
Paragraph number 4 of that order. A new scheme of management of work was notified by the board in terms of power under Rule 48 of the Karnataka Work Rules 2017. And the scheme of administration of the work is dated 16/6/2022, which is the scheme in subsistence as on date. Since the managing committee to be said that the proposed work was not in existence, the district officer takes over the work and initiate proceeding for conduct of elections and issues calendar of events. The issuance of calendar of events and the order to enroll members of the work is what drives the member of the work to this court in the subject petition. The learner senior counsel taking the court through the scheme of the management would contend that at the outset the managing committee should be selected on the consensus in terms of clause 2 of chapter 6 of the scheme, and if no consensus is arrived at, and it is only then the election should take place in terms of chapter 6 of the scheme. Since the present action is by the district officer, it is without jurisdiction, it is the submission of the learner senior counsel. The counsel on the other hand would refuse the submission, taking this court to the rule 54 of the rules to submit that if the managing committee is in existence, then chapter 6 would come into play, and on the failure of the consensus, chapter 8 would then become applicable. Since there is no managing committee in this case, in the case at hand, the election is the only mode, and the district work officer taking over the work for the conduct of election is valid in the eye of law. Therefore, this honorable court, the two cognizance of the implemented of the scheme and also held the election is valid in the eye of law. Therefore, now at this stage, the scheme.
What is this, Mr. How many times you file petitions on the same cause of action?
No.
Huh?
It's not, no, my lord, it's not same cause of action.
Particular.
My lord, sir, just,
Last paragraph.
my lord, sir.
Per
just-
contra, learned counsel for the respondent work board has drawn the attention of this court to an order passed by this court in another writ petition filed by the very same petitioner.
No, very same petition.
Yes.
Yes. Siddhi, kindly see, my lord.
Which has been made upon by.
No, my lord, kindly see. Don't mislead the court.
Oral.
My lord, sir.
Filed by one UB Siddiqui in WP number 1828 of 2023. Dated 7/2/2023. So, learned counsel submits that this court has already taken note of the impugned order dated 16/6/2022 in paragraph number 8 and has held that the scheme is notified by the board in terms of Rule 48 of the rules as part of the scheme of administration of the Waqf. Stop. this court has also taken note of the fact that in terms of the scheme, a consensus could be arrived at by selecting a managing committee of the general body in terms of chapter 6 of the act. Stop. In that way of the matter, it is submitted that there cannot be a stay of the impugned order, since subsequent developments have happened consequent to the impugned order. Full stop. Yes.
Those writ petition have not challenged the scheme.
Let us see.
My lord, scheme.
List this matter after Dasra vacation. We'll consider. Yes. A week's time is granted for complaints of office objections. Other Nimdala, next matter. Yes. List this matter after service of notice on response number 3, 4, and 7.
Appear for the response number 5 and 6.
You already said, so they had something to respond to the 7.
Lord, sir, appear, my lords, one
3
small
and 4.
submission. Small submission,
Yes.
my lords, in this case. And for response number 5 and 6.
Ah,
Last date of hearing, your lordship has noted that why action should not be initiated against respondent number 5 and 6 for collecting pre-MI from the petitioner.
Where is the statement of objections?
what is it?
Petitioner, the lordship may direct the lord of the government advocate are free to accept notice for R2, my lord. R2 is also a government ministry.
All right, you file your objections.
The
I'll-
minister will be the
File your
chairman
objection.
for that
Consider-
single window.
WP number 463.
Only one submission is that 138 case has been withdrawn, that may be recorded.
ಅಲ್ಲ,
Learned
R2
counsel,
ಗೆ
the petitioner submits that the hand summons taken to respond number 7 has been served. The hand summons has been filed in the office. Yes. Yes.
31.
Yes.
Second time.
Interim order granted earlier stands extended till the next date of hearing.
31.
This lord, I appear for the petitioner, my lord. Your lordship
Yes.
can direct the government advocate to accept notice on behalf of the R2, my lord.
Yaro?
R2 ಗೆ
Sukruta. Learned counsel, Miss Sukruta is requested to take notice for respond number 2 and 4. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for response number 2 and 4.
date will be fixed, my lord, for the hearing. Because the scheme lapses.
ಇಲ್ಲ ಇವಾಗ ಏನಾಗಲ್ಲ. ಇವಾಗ ಆಗೋದಿಲ್ಲ. A week's time is granted for compliance of office objections.
ಅಲ್ಲ, after vacation ಯಾವ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
ಇಲ್ಲ ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಇವಾಗ.
I appear for specification. The last occasion the matter had come up, my lord was pleased to vacate the interim order. Maybe taken up after vacation.
List this matter after Dasara vacations. In the meanwhile, the office objections raised on the statement of objections filed by respondent number 4 shall be complied with. List this matter after service of notice on response number 3 and 4. List this matter after service of notice on response numbers 1 and 2. Same. List this matter after service of notice on response number 1 to 5.
The action date 27th, and before that one date, I will take a chance, because the 27 action is held, my petition are virtually infractious.
Yes, sir.
Bank issued the notice Page 23, annexure B.
Non-compliance of office of non-compliance.
I got a point in section 14 proceedings.
Ah.
Bank and issued notice, section, page 23, annexure B, please see my. I'm at 1A, I'm the wife of the deceased borrower. Subsection is that my name is not found in the impugned order. Page 23, please see my. The bank has issued notice to me, I am the wife of the deceased borrower.
Believe their office objections. Believe that. Different side. Yeah. Yes.
My name is not in the.
ಆತರದೇನು ಇಲ್ಲ ಅಲ್ಲಿ.
Challenging section 14 order.
ಹಾ.
The regular loan was regular till my husband was alive. Only from 2021 after his death. The repayments are not made in time. 8 crores 45 lakhs is the only.
ಯಾರು? Who was the borrower?
Borrower is my husband, Abdul Aziz.
ಯಾವ ಕೊಟ್ಟಿದ್ದಾರೆ? Petitioner is not party before magistrate.
The bank has not chosen to make me a party, but has issued notice to me. Page 23, annexure B may please within my lord. There is a notice issued by the bank to me. Therefore, I am entitled to challenge this order.
Your husband is the borrower.
Yes, please.
Huh.
The office objection may please be overruled. Husband died in 2021.
Huh.
Bank initiated section 14 order against my husband and some other strangers. I was not a party there. But notice has been issued to me for recovery. Page 23, the notice issued to me. One A is, my name is at 1A. They may take physical possession.
You have received the notice in the month of July 2022.
Please, my lord.
What did you do?
Order is passed in March 2023.
What did you do after receiving the notice, sir?
No, I was approaching the bank for some settlement. Subject to usual terms, your lordship may kindly give me some instruction, please.
7 crores 55 lakhs, sir.
Whatever is the condition. Huge property worth about 25 crores, I'm getting you rent also. Rent is going directly to the bank. I should notice it to the tenants also to make payment directly to the bank.
Issue emergent notice to the respondent. Next para, learned counsel for the petitioner submits that the respondent bank has approached the jurisdictional magistrate without making the petitioner herein a party to the proceedings. And although the bank knew that the borrower, late Mr. Abdul Aziz, husband of the petitioner herein, had died in the year 2021. So, then a counsel submits that the order has been obtained against a dead person. Full stop. However, a notice came to be issued by the respondent bank to the petitioner, calling upon the petitioner to repay the outstanding loan amount. I don't think there was only one borrower. There may be more borrowers.
One borrower.
Who are these persons? Shagufta and Syed Aslam Basha, who are they?
Made some changes as husband and wife, I mean, the wife and the son of the borrower is.
ಹಂಗಾದ್ರಾಗಲ್ಲ.
ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಬಟ್ OA ನಲ್ಲಿ ಆಮೇಲೆ ನೋಟಿಸ್ ಅಲ್ಲಿ I am also made a party. But bank is quite a OA, wherein I am a party, 1A.
Nevertheless, learned counsel submits that the petitioner is having sufficient income from sufficient rental income, and if reasonable time is given to the petitioner, she will be in a position to clear the entire outstanding loan amount. So, in order to show the bona fides of the petitioner, it is submitted that the petitioner will deposit 20% of
It goes 45 lakhs. Both, there are two loan accounts, both put together.
rupees 8 crores,
45 lakhs, 72,418.
within a period of 4 weeks from today. So, next para. Consequently, the respondent bank is directed not to precipitate the matter any further, subject to the petitioner depositing 20% of rupees 8 crores so and so within a period of 4 weeks from today with the respondent bank, failing which the benefit flowing out of this order shall not inure to the petitioner, and the petitioner will be at the risk of having the writ petition dismissed. Release this matter on 10th of November.
Parties in the section 14 order are guarantor.
Huh?
They are the guarantors.
Aura. All right. Huh?
The office is insisting to produce the entire CPD. It may not be relevant for research.
Regarding office objections, learned senior counsel appearing for the petitioners would submit that ಯಾವ annexure ಅದು? Huh? In annexure N, L, only the relevant pages are furnished as a typed copy, since the document is bulky. We stop. The submission of the learned senior counsel is accepted and office objection is overruled. Yes.
A notice of issue came to issue the respondent bank under section 32 and 4, and a petition can be filed by the petitioner in WP number 1541/2022. There is an interim order subject to payment of 30%, that interim order has been complied. After the order passed by the Honorable Court, then they made an attempt to take possession under section 14 by obtaining the permission from the federal magistrate. Then I filed a writ petition, another writ petition in WP number 16816/2022. There is also an interim order, they said interim order has been complied. The Russian annexure A, they treated at page 21. After the order passed in the first petition, they treated my loan as non-NPA. Page 21, paragraph 1.
Yes.
That your loan account number 12 was previously classified as non-performing asset on 9th August 2021 due to non-payment of monthly due, which had remained outstanding for over a period of 91 days. Thereafter, principally payments made to the account. The loan amount was declared as non-NPA on 17/2/2022. They treated, but it has not been intimated at all. Then, hence, the previous demand notice stated so stands draft in section C and D. However, considering the non-payment of monthly MA, your debt loan account has been classified by our company as non-performing asset. Page is similar. I have paid at page 100 audit report in Madina. I have produced the account also at page 190 minute. As an EMI minute, I was liable to pay at page 191. 1 crore as a payment. At page 191, article for the money. 191. 1 crore first minute. 1 crore 33 lakh 10,220. What I paid minute 1 crore 65 lakh 12 so. The excess amount still with the bank is 32 lakhs and all. In spite of this minute, as per connection in AP, again they have issued a notice under section 32 and 4. Stating that it is MP. Similarly, as per a payment made by me.
Where is the statement of account? Where is the statement of account, sir? They have very clearly stated that though it was declared non-NPA on 17/2/2022, subsequently you have again default. More installment ಕಟ್ಟಲಿಲ್ಲ ಅಂತಂದ್ರೆ it will become NPA again. Yes.
Treating an NPA. This is the amount paid subsequently after the order.
ಯಾವ ಅಮೌಂಟ್ ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಾ?
Page 86, page
86.
Page 86. Account extract from my bank.
ಅದನ್ನೇ ಕೇಳಿದ್ ನಾನು. Yes. Yes.
Page 86.
ಹಾ.
Minute. And in page 86. Plus to page minute. Top second line.
86. ಹಾ.
5 lakhs ಕಟ್ಟಿದ್ದೀನಿ. After the
Sir, that was February 2022. After February 2022. March, April, May ತೋರಿಸಿ. ಇವೆಲ್ಲ ಫೆಬ್ರವರಿ ಇದೆ.
Payment made after the implement passed by the report after February 2022. This is the payment made after the order made in WP.
ಏನ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ ಸರ್?
On 62/2022,
I
have paid 5 lakh.
ಆಯ್ತು.
10. Page 85. About 9 from bottom. This is on 62/2022, 5 lakh.
Same date. Same date it is.
10, 16, ಅವತ್ತು ಎಲ್ಲ ಒಂದೇ ಸತಿ ಕಟ್ಟಿದ್ದೀನಿ ಅವತ್ತೇನೆ. Another 10 lakh. Then 17/2, 5 lakh. On same day, another 3 lakh. These are all after the interim order. That is the first interim order passed by the report. Those petitions are still pending consideration. Then my lord. Then page 83. 23/3/2022. 1.5 lakh. Page bottom in it. ಕೆಳಗಡೆಯಿಂದ ಹಿಂದೆ ತಲುಪಿದೆ. 1.5 lakh. On 23/3/2022. Then my lord, on 29/3/2022. Then previous page 82. 6/4/2022. 1 lakh. Then page 81. 21/4/2022. 10 lakh. And 25/4/2022. 4.5 lakh. Similar page 79. It is the unit.
What is the VMI that is payable?
2,74,000.
74,000.
Huh?
2,75,000. First it was 1,70,000.
The EMI at this page, B. 1,98,660. 1,98,660.
It was 90.
Whatever the amount paid under this account method, I have calculated at page annexure in P method at page 190. Till no method, I have paid 1,65,00,000 lakh, 28,000, 32 lakhs still is in the account of the bank. Excess amount.
But that is not so. That is not so. If this is the statement of account, then but there is no balance.
Yes, that's all. There is no balance actually.
Allah, there is no balance in your account. Please see the last column. Please see the last column in page number 76, 77, 78. They have taken whatever payments you have made into consideration.
ಇದು ಅಲ್ಲಲ್ಲ ನನ್ನ ಅಕೌಂಟ್ ಇಂದ ಹೋಗಿರೋದು ಸ್ವಾಮಿ ಇದು ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಅವ್ರ ಬ್ಯಾಂಕ್ ಹೋಗಿರೋದು ಎನಿ ಅಕೌಂಟ್ ಎಟ್ ಆಲ್ ದಿಸ್ ನನ್ನ ಅಕೌಂಟ್ ಇಂದ NFT ಹೋಗ್ತಾ ಇರೋದು ಇದು.
ಹೌದು ಸರ್, ಪ್ಲೀಸ್ ಸಿ ದಿ ಲಾಸ್ಟ್ ಕಾಲಮ್.
ನನ್ನ ಬ್ಯಾಂಕ್ ಇದು
ನಿಮ್ಮ ಅಕೌಂಟ್ ಲಾಸ್ಟ್ ಕಾಲಮ್ ನೋಡಿ. ನೀವ್ ಹೇಳ್ದಂಗೆ ಏನು ಹೆಚ್ಚಿಗೆ ಏನು ಅಮೌಂಟ್ ಏನಿಲ್ಲ ನಿಮ್ಮ ಅಕೌಂಟ್ ಅಲ್ಲಿ. Whatever your payment made, that is taken into consideration. But that is not meeting the requirement of your payment of EMI. That is why they have given a notice to you.
The account ನನ್ನ ಬ್ಯಾಂಕ್ ಒಂದು RBI ಬ್ಯಾಂಕ್, ನಾಟ್ ದಿ ಅಕೌಂಟ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡಿಂಗ್ ಬ್ಯಾಂಕ್. ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಈ ಅಮೌಂಟ್ ಕಳಿಸಿರೋದು ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇದು RBI ಬ್ಯಾಂಕ್ ಮೈ ಅಕೌಂಟ್. ಮೈ ಅಕೌಂಟ್ ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ನಾನು ತೋರಿಸ್ತಾ ಇದ್ದೀನಿ ತಮಗೆ.
ಯಾರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ಯಾಂಕಿಗೆ ಕಳಿಸಿ ಅಲ್ಲಿ NFT ಎಲ್ಲ ಇದೆಯಲ್ಲ, NEFT ದಿ ಅಕೌಂಟ್ ಆಫ್ ದಿ ಬಜಾಜ್ ಅಕೌಂಟ್ ಹೋಗ್ತಾ ಇರೋದು ನಾನು ತೋರಿಸಿರೋದು. ಇದು RBI ಬ್ಯಾಂಕ್ ನನ್ನ ಅಕೌಂಟ್ ಇಂದ ಅವ್ರಿಗೆ ಆ ಲೋನ್ ಅಕೌಂಟ್ ಹೋಗ್ತಾ ಇರೋದು. They are not publishing any account at all. ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ದುಡ್ಡು ಕಟ್ಟಬೇಕಲ್ಲ, ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಈ ಲೋನ್ ಅಕೌಂಟ್ ಹೋಗ್ತಾ ಇರೋದು ನಾನು ತಪ್ಪು ತೋರಿಸ್ತಾ ಇರೋದು. ನಾಟ್ ದಿ ಅಕೌಂಟ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ಯಾಂಕ್. ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಅವ್ರು ಕಟ್ತಾ ಇದ್ದೀನಿ ನಾನು ರೆಗ್ಯುಲರ್ ಆಗಿ. RBI ಬ್ಯಾಂಕ್ ಮೇಲೆ ಇಟ್ ಇಸ್ ಮೈ ಬ್ಯಾಂಕ್. Which may not. It is 65 RBI ಬ್ಯಾಂಕ್. ನನ್ನ ಅಕೌಂಟ್ ಇಂದ ಅವರಿಗೆ NEFT ಮಾಡ್ತಾ ಇದ್ದೀನಿ ರೆಗ್ಯುಲರ್ ಆಗಿ.
What is the reply that you have given
Annexure U, madam.
to that notice?
Annexure U.
Page number 183. Yes. Yes.
But that is so and so.
Yes.
Read from three minutes. I can further instruct me to state that the case of the road agreement by right without any irregularities up to 2020, no EMI has been due. Due to COVID-19 pandemic, the Honorable Indian government measure.
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ ಸರ್. 2022 ಹೇಳಿ ಸರ್. Afterwards, they have very clearly said that though it was declared non-NPA February 2022, ಮತ್ತೆ you are defaulted and May 2023 it has been declared NPA ಅಂತ ಹೇಳಿದ್ದಾರೆ. For that one, what is your submission? Yes.
Even though 34 notice, you have also fixed the time for 60 days and also the Honorable Court stay the further proceeding notice date is over. By you having filing sections 14 of the SARFAESI Act before so and so, the said petition has been allowed on 11/4/2022 while passing the order by the magistrate. The time has been fixed for taking over the physical possession of the property for 2 months. Isn't better. Paragraph 9.
Yes.
My client further instructed me to state that in both two writ petition, my client paid a sum of rupees 74,56,551. Silver loan account in the year 2021. In 32 notice, you have demanded 2,93,14,388.
You have not said anything about your payment after February 2022.
Granted by this under we have applied the entry order and we have deposited 74,56,551. For the writ petition. Then they are treated as a non-NPA. As on 17.
What do you say now? We can't dispute the facts. They have said so in their notice.
The account extract produced by me, this is the amount which I.
Sir, in your reply, you have not said so. If that was your contention, you should have been said so in your reply. Issue emergent notice to the respondents. Read this matter on 25th of October. Yes. You received a copy?
I served a copy on 7 itself. By that time, the order should be implemented, your lordship. The order is not, I should have. 39. But may not really see the order. Copy has been served on me. On 15.
My father expired on the day. Only call, but on the day.
Kindly see the which I have.
But unnecessary.
Order passed is not without jurisdiction, not the petition is residing at Madhu, and that is the. The family court has to exercise the power. But as per section 9, you will ask. The matter was dealt by the Mascota senior civil that Bangalore rural district.
Sir, that objection you should have raised there itself. Not possible.
Yes, I have raised the objection.
Right. We will consider it later.
No, may one submission.
Yes.
Then the direction also, one son, my lord, there are two sons, your lord. One son is residing with him. One son I was thrown out along with you for the second child, your lord, who is studying third standard at Madhu. I am staying in Madhu, your lord. And I am a MSc mathematics teacher, your lord. Working as a mathematics teacher. This is software engineer. I was thrown out in 2022. I have been residing at Madhu Milot along with my family, along with my parents, even without maintenance, your lordship. He files a petition, Milot, audience wants that petition, Milot, before the district and session judge Bangalore rural district, your lordship, which were transferred to the Cooperative, Milot.
What is the reason for passing the impugned order?
Now Bangalore is in.
Huh?
Now we are unable to look after the welfare of the child, that's what they say. And
You please point out from the impugned order.
para 10 my lord, para 10.
Yes,
Here in this case, whether the petitioner is entitled for an interim custody of minor child, the respondent number 2 is to be decided at this stage. Before going to the allegation made by both the petitioners and the respondent 1 in their pleading, on perusal of the available records, it clearly goes to show that the respondent number 2 is in the custody of respondent number 1, and the another child is in the custody of the petitioner, this petitioner. The petitioner in his affidavit filed along with the application stated that the respondent number 2 is residing in his maternal grandparents' house at Baddur, and the respondent number 1 is residing in Bangalore by working in a private school as a teacher. That's what the allegation was. I have been deciding, please see the address given by the
address address also
I am deciding avare kottiro address nane.
You are working as a teacher anta heltaralla. You are working as a teacher. Where?
In Bangalore, Lord. In Bangalore, I am working as a teacher, Lord, in JSS College, Lord. Every day I travel, Lord. Morning 8 to 3 o'clock.
And the children are admitted where, in which school?
Baddur school, Lord.
So you are in Bangalore, the
Even the first change, Lord, is with the husband, Lord. He is in Vaskote. First change, Lord, is 10th standard, Lord. He is with the husband. The second stage and myself, Lord, was thrown out, Lord, in 2022.
Yes.
Therefore, Lord, I got admitted my child, Lord, to be studying 3rd standard at Madhur Taluk, Lord, in Madhur town, Aishwarya International School. At that juncture, Lord, when I was thrown out from the house, Lord, I filed a petition, Lord, dowry prohibition case, Lord. When the case was filed, Lord, after that, Lord, he files this petition, Lord, seeking custody of the child. In that, Lord, even notice has started being served, even though the address was given by him, Lord, is one and the same. He is avoiding this.
No, this child who is with you
Yes,
is studying in which school? Where?
Standard, Lord, and Aishwarya International School,
Madhur
town.
Then ಮಧ್ಯದಲ್ಲಿ ಈ ತರ ಅವ್ರು ಕೊಟ್ಬಿಡಿ ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ? Where should the
What they have done is
you will consider
this order will go to the police station.
learned counsel Shri Babu has entered appearance for the respondent by filing a caveat petition. Learned counsel submits that he has received a copy of the writ petition along with annexures. Full stop. Next para. Learned counsel for the petitioner submits that when admittedly one of the two sons of the petitioners is residing with the petitioner in Madhur and going to a school in Madhur in 3rd standard at Aishwarya International School, by passing the impugned order, the learned judge has directed the petitioners to hand over the child to the respondent
1 month in the date of the order,
without even application of mind as to what should happen to the schooling of the child. Full stop. Next para. Consequently, there shall be an interim order of stay of the impugned order till the next date of hearing. We will consider. Let us consider, sir. Yes.
Typed copy of page 86 to 89 is part of the voucher, my lord. It is not relevant. It's on screenshot and format, not the name.
Yes.
There is sketch, particularly not always under objection.
Of his objections are overruled. Yes.
Years of the cases, my lord. So the first respondent is competency. And the third respondent. The petitioner is the landlord. So that this is relating to retail outlet dealership of a petrol pump. So that as per the brochure of the first respondent, my lord.
Direct respondent number 1 not to supply petrol and petroleum products to the petition scheduled property.
Petition scheduled property belongs to the petitioner, who is the landlord. Lease was for 15 years. And got terminated in February 2023.
ಆ ಟರ್ಮಿನೇಷನ್ ಆದ್ಮೇಲೆ if they have to-
issue emergent notice to the respondents. Yes. No.
Manish Kumar KB.
No, not now. Let them come. We'll see. Yes.
Therefore, not any date of application.
Date ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಈಗ. Yes. Huh? Non-compliance of office objection.
Father has passed away, but he has to go to his hometown for the purposes of all the ceremonies. And seeking.
Learned AG takes notice for all the respondents. HCDP. Learned counsel for petitioner is directed to serve copy of the petition along with the annexures on the learned HC. One more you will have to furnish. Next para. Learned HCDP is directed to secure instructions from the third respondent in the matter of
Emergency.
application made by the petitioner seeking emergency parole. So, the petitioner is permitted to move the vacation bench. ಹಂಗಾಗೋದಿಲ್ಲ ಸರ್. No.
230 PM matter.
Yes.
Case number 45. It's an auction is day after tomorrow. On some condition, that auction may be stayed. Case number 45. I moved the bills last week. Trying to.
2022 matter.
ಈಗ ಆಕ್ಷನ್ಗೆ ಹದಿಮೂರನೇ ತಾರೀಕಿಗೆ that are sought for a stay. So last may consider on some conditions.
You are appealing for the respondent. What is the matter about?
And that I it is not.
Please wait, sir. We'll see. We'll take it up in the end if it's possible. Yes. We'll continue with that previous matter.
Serial number 68. Further argument 230 PM matter.
Yes.
44 auction is scheduled on.
We will see, sir. If time permits, we'll see. Otherwise, not possible. We will see. Not now. We'll see.
Serial number 58.
See, this matter is going on from 3 days. We have to conclude that one.
Anything about petition only of costs. Because there is an interim, there is a comment order in our favor.
All right, we will have it tomorrow. We will have it tomorrow. Huh? Yavado name serial number 67. Release this matter tomorrow at 2:30. Yes. Interim order granted earlier stands extended till next date. Yes. ಅದು CRPC ಮತ್ತೆ IPC. Yes, sir. No, this is specially ordered matter.
Because it was not.
Huh? ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ sir. No, no, no. No, no, you can make your submissions on the merits of the matter, we will see. All right, let us, yes. ಅದೇ. Yes, yes. Yes. Yes, yes.
Other non-cognizable offenses. The non-cognizable offenses, there is no the characteristics of the. In the event of the investigative conclusion. No cognizable offense as such has been done. Result of the investigation which we does. We entitled to a charge sheet that. In relation. Non-cognizable.
Yes.
I also submit to your lordship. An reference submission being. The pay constituted an offense of section 176. He also added one more, even among the offense of section 190. And may not go there to me. Is there a prohibition for the court to take cognizance of the offense? Made in the 177, 182, 195. You have the mandate of law, section 195, 1A of this year is.
Yes, yes.
But at the outset, let me invite the lord's attention. The court has not chosen to take cognizance of the sensitive.
Yes. Yes.
Therefore, the provisions of section 195 are absolutely no application.
Yes.
But even otherwise. But what will happen so that we want to use? It comes within section 195. Any one of the offenses that are found in section 195 is here. The magistrate, for conclusion of trial and transfer of judgment in the case, he has got to follow the procedure that is mandated in section 340 of the CRPC for the submission which can be made by Madam. Then invite my lord's attention, section 340 per second, however, section 340 per second.
340 of the CRPC. Yes.
Here, in this speak up otherwise, you know,
Yes.
Any point of the opinion that is expedient in the interest of justice that is inquiry to be made in the offense, therefore, it laws be of subsection for any. Very fast for a minute. Here 40 refers only to offences that are enumerated under clause B of subsection 1 of section 190. That's holding in mind. And subsequent there, in the event of the result of the inquiry which to be ordering, disclosing the commission of offences that are found under subclause B of subsection 1 of section 195, then my lord, it should not be otherwise. Of B of subsection 1 of section 195, which appears to have been committed either in relation to a proceeding in that court. The offense should be the one that is related to the proceedings in that court. But if an offense has been committed beyond the scope of the proceedings of that case, or much earlier, you go to the registration of a crime and the filing of a charge if an offense has been committed, when it does not come within the ambit of. So that the court would invoke its jurisdiction under section 6. But now, may I request you, Lordship, to kindly have a concern look at section 195, 1B of the CRS. B. But my first submission to Lordship is here. Cognizance is for other offences under the APC, and certainly not the one that are referred to in section 195, let alone under 195, 1B of the CRS. Have a look at 195, 1B. But it actually is no court shall take cognizance. How can it will be even of any offense particular in the area, the following sections indicated in the report, namely 193 to 196. 199, 200, 205, 128. Such offenses are identified committed. Even in relation to any proceedings to be filed. The offense that is committed in relation to proceedings. Two small moment of any offense is granted section 463 and 20. Such offenses are to be committed in respect of a document used and given in evidence in a proceeding in any court. Or when you give the conspiracy to commit the attempt to commit or the abatement of any offense specified in subclause 1 of and reason B. It is not related to any one of the offenses in respect of which trial take cognizance and all. But now for a second, when the prohibition is imposed not upon the complainant or the police who upon completion of investigation would find a final report in the Department of Justice. But as a member of the public, I can go and present a complaint report. As an investigator, I can go to the court and submit my finding. There is no prohibition for the submission of the complaint or for the submission of the final report by a party or by the state, but the prohibition is imposed to be upon the court.
Correct.
Prohibition is, I think I made myself
Correct.
clear.
To take cognizance. To take cognizance.
Take cognizance.
Yes.
But now, the 8%. 198%. All these 195, 196, 197, 198 are all in the relation to the prohibition that is imposed upon the court. It is various offences that are enumerated of those provisions. Now, kindly have a look at section 198 for a second. But this is new. In relation to offences against marriage. Of course, shall take cognizance of the offence punishment in chapter 20 for the 18th, except upon That is 195. No court shall take cognizance of the evidence except upon a complaint made. Here, except upon a complaint made to a person is agreed. This is unfortunate. In parameter 195, 1B is settled in parameter with 198. The prohibition there is related to settlement, except upon a complaint made to the court. Here, no court shall take cognizance of an offence except upon a complaint made to the person who is agreed. But then you get ABC for the persons correctly. 195, 1B, 98 are almost parameter. Division was another statute against it. Okay, just a quick lot here. See what the Supreme Court said. What should parent has to? Finish. Also, relation to by putting the provisions of section 198. Just because you got it. I think it's very good. And very good. Second. I think 96, 106 Supreme Court cases, 455 in the case of in the song, another, which may not get at page 132. My comparison, page 132. The police, not dependent to I got 7, page 134. But this was a prosecution from 494. But this would be a reference against marriage. The prohibition of section 198 for the court imposed upon the court. This is accepting upon by certain class of persons armed with 98 A, B, and C. But kindly go to paragraph 7. The relevant portion of section 198 which deals with the prosecution for unsubstantiated marriage provides and I shall skip these 198 A, B, and C. These provisions set out the prohibition for the court from taking cognizance of an offence punishable under chapter 20, 83 and 4. The cognizance, however, can be taken only if the complaint is made by the person aggrieved by the offence. Clause C appended to the proviso subsection 1 provides that where a person aggrieved is required, a complaint may be made on their behalf by her father, mother, brother, sister, son, daughter, or other relations within the so related to the blended marriages. I go now page 135, paragraph. Now itself, they are not to quote the currency section 155. That understanding is not there. Kindly go to 155. Information into non-cognizable cases and investigation such cases. They are quoted section 155. Then paragraph 10.
Subsection 4 of this section clearly provides that where the case related to two offences of which one is cognizable, this is what I said earlier, one is cognizable, the case will be deemed to be a cognizable case, notwithstanding that the other offences are not. Subsection 4 creates a legal picture and provides that all the case will be comprised of several offences which are cognizable and others are not. It would not be open to police to investigate the cognizable offences only and omit the non-cognizable offences. What case comprising of cognizable and not cognizable offences is to be treated as cognizable. The police has no option but to investigate the score of the case and to the people charged in respect of all the offences, cognizable or not cognizable. Both provided is found by the police to the investigation that the offense is primarily. Subsection 4 of section 155 is a new provision introduced for the first time in the code of 1973. This was done to work on the controversy of investigating the offences by the police without the legal defense. Statutory provision is specific, precise, and clear, and there is no ambiguity in the language employed in subsection 4. It is apparent that if the facts report to police disclose both cognizable and non-cognizable offences, the police will be acting within the scope of its authority in investigating both the offences, as the legal section enacted in subsection 4 provides that even in non-cognizable case shall in that situation be treated as a cognizable. This was a very interesting AP has had that while investigating a cognizable offence and presenting a charge sheet for it, the police are not debarred from investigating in a non-cognizable offence arising from the same facts and including them in the charge sheet. Like court is a very important. High Court was thus clearly in the air. In fact, the charge sheet under section 494, that is the case where the police would file a charge sheet for another in the section 494, which gets covered under section 198. No court shall take up business. The High Court was thus clearly in the air in quashing the charge sheet under section 494 ABC on the ground that the trial court could not take cognizance of that offence unless the complaint was filed personally by wife or any other relation contemplated by clause C of the provision of 198. Now, but my submissions in this regard are important. My first submission to Lordship is the offences which were narrated as canvassed as the 131 that 5 years ago, they being 177, 182. In fact, are not the offences in respect of which cognizance is taken. Even others, if you were to disclose the commission of offence, but when the magistrate hears the account and the prosecution in exercise of the powers flow upon him under section 439, the Lord may report your lordship to the admitted your lordship can attention. At that point of time, it is contained. This is not the offence that is made up. This is the offence that is made up. Nothing the magistrate while hearing the truth there. Under section 239, can certainly create a charge, although that charge is not the one that is included in the final report by the case, and which charge will be based on the evidence in the investigation they have collected and not. Even here also, but however, ultimately, he may even when he hears the parties to the case of the section 239, he can certainly proceed to claim a charge, not only for other offences in respect of the charge that is required, also for offences against that is one such offence being 177, 182, and 195. With absolutely no bar. When there is no bar for the court to have taken cognizance in the basis of a charge sheet for an offence under section 494, actually filed by the police, not being the wife, not being the daughter, not being the son, not being the father, not being the mother, or any close relation of the aggrieved. Supreme Court said, High Court was in error in quashing the proceedings on this score that is the prohibition under section 198. A, B, and C. Not going back. But because of panic and the next statement which are used. Following the statement. I could say. States, what the Supreme Court would say, one line. Paragraph 3. We can't go into the facts of the instant case, the above view of the High Court is proper or not, for the improved proceeding has got to be required, and then the police was entitled to investigate. Are the chief judicial magistrate to take cognizance of the report submitted? Such investigation. Showing the police, and they hear the police themselves in their report to say so. The offense of section 30 of the Act is non-cognizable. Therefore, the police could not have registered such an offense. First, the police is entitled to investigate the non-cognizable offense. Pursuant to an order of a competent magistrate, this is how I submitted your option. The other day, the non-cognizable offense. Pursuant to an order of a competent magistrate. Admittedly, no such order was passed in the incident case. That necessarily means that neither the police could investigate into the offense in question, nor submit evidence which question of taking cognizance could have right. Well, at this point, it will be mentioned that in view of the explanation in section 2D of the CRPC, which defines complaint, the police is entitled to submit after investigation a report relating to a non-cognizable offense, in which case such a report is to be treated as a complaint of the police officer concerned. But that explanation is not available to the prosecution. As in this case, that is not available to the police. So, my lord, even if you were to file a charge, but non-cognizable offense, then you can't throw that complaint out on the score that you have no jurisdiction to have the native without planning the office of the magistrate. Yeah, my lord. Now I need to pay 121 now. We go to this again, my lord, section 493. 804 now. I got 7. Here again is a bar. No posted take cognizance. To be on the facts of this case, it is clearly clear from Article 8 charge sheet that the magistrate provide a complaint and the commission of offences include the cognizable and non cognizable. So it is not a case of competency here. It is a case of police who directly investigate crime, not only for cognizable as well as non cognizable cases. During investigation, the investigating officer found that only non cognizable offense was better. What we did find, and it is A. Finally, acting as a final report, the learned magistrate proceeded with the cognizance of the offense and given an D. Now, section 198 of the CRPC provides that no court shall take cognizance of an offense punishable in chapter 20 of the Indian Penal Code, except upon a complaint made by some persons available by the evidence. If complaint rightly lodged the complaint before the proper court, which it does forwarded to the police for investigation, since the complaint alleged commission of cognizable and non-cognizable. At the same time, section 2D of the CRPC defines, let's keep the order. Page 6. Reading the explanation to the definition of the 2D of CRPC, it is clear that a report made by a police officer in a case with disclosures of investigation, commission of a non-cognizable offense, It will be deemed to be a matter. This police officer will, such a report is made, it will be deemed. So that counsel for the petition and applied with taxes. He has placed it, this should be affect for the case state police officer charge to stop from them. One to check everything. We should keep that around and it should take a lot. Section 155 4CR is there. We reduce. Kindly go to page 149. In conclusion, we came to the right with what? Applying the ratio of charitable service in the facts reported in the police to those who are competent and uncompetent. The police will be acting within this in investigating both the offences as a legal fiction and acting both right, and even a non-competent shall in that situation be treated as a competent. The law is certainly the facts of the case. Though the magistrate forwarded a complaint involving offences competent and uncompetent. Police files a report finding that non-cognizable offence was committed. The magistrate is legally able to proceed with the trial. If so, the contentions arising by the law counsel for the petitioner in the facts of the case. But if ultimately the result of the investigation will disclose the commission not. Despite there being a bar under section 198 or even under 195, that the court indeed is entitled to take cognizance of the offence. Second limb of argument. The first limb of argument is 195 3-party has absolutely no application at all. But probably you will not may say, no, the offences in the cognizance can be taken by the magistrate. They be one under 120B and other than. But 120B is also a non-cognizable offence. 201 is also a non-cognizable offence. In addition to that, in the first information report, on the basis of the time to be registered and finally report has been filed. Now let me confine myself only to these two non-cognizable offences, irrespective of the other offences that are alleged against it. It is so for this reason, the Lordship can report the Lordship's memory. My submission to Lordship yesterday was these two petitioners are tagged on to the case only with the aid and assistance of 150B. That's all I submitted to the Lordship. I drew my Lord's kind attention to the objects in which one of the petitioners would throw the mobile phone, those who the husband came to be arrested, into a dustbin. And in the other mobile phones came to be seized by the investigator. Such of the premises of the first petitioner found missing. It is in the commission of the council. Its focus 201 is a non-profit. 120B is a competency. I drew my lord's statements of several of the witnesses. The recovery pension statements with voluntary that they led to the recovery of certain huge amount which was offered procedural right to the innocent. But now we are many have looked at it is very poor. But you have to probably pose a question to me. We tell conspiracy is 120B. Conspiracy is for what? Probably you will not pose a question. I'm assuming that you will. But conspiracy is obviously for the purpose of commission of an offense. If the offense itself is not there, but if the offense itself is not there, could there be a charge? Or could the court was entitled to take cognizance of the offense of 150B? That doubt may arise in the Lordship's mind. I'm going to answer that. Thinking that my Lord may entertain the doubt.
No, you said that it is a standalone provision. Yes.
But 120B, irrespective of the fact that the conspiracy is going to be hatched, it not necessarily for the purpose of the offense that was committed. Even if they had thought of or hatched the conspiracy for the purpose of the commission of a particular offense, even if the offense is not there, or not committed, or could not achieve the object of conspiracy, 120B is a standalone offense. But even when charges are framed under section 211 and 212 of the CRPC, but where an offence under section 120B is also there in the final report. And the draft could always proceed to implement independently for 120B. In relation to the rest of the offences, they will say, although he is not a participant or he has no role whatsoever to have played directly in the commission of the other offences, he gets charged. Both offences, the aid and assistance of 120B. First lay for conspiracy, then allow the aid and assistance of 120B in relation to other offences. What the say. And just request your lordship to kindly turn to violation. Page 1. When Yogesh alias Satyajit was the state of Maharashtra, in 2008, volume 10 Supreme Court cases 394 is what the Supreme Court would say. May I request your lordship to kindly turn to paragraph 25 for a second. It is page 59, my compilation. In page 59. It is page 402. It is manifest that the meeting of minds of two or more persons an illegal act. An act by illegal means is a sign for law of the criminal conspiracy. But it cannot be possible to prove the agreement between by direct. Here, we got a lot of memory. How the prosecution has look at these petitioners into this case with the aid and assistance of 120B. I invited the Lord's attention to unimpeachable oral and documentary evidence with the investigator and collected the reports of the investigation of the crime. You know this. Nevertheless, existence of the conspiracy and its objective can be inferred from the surrounding circumstances and the content of their clothes. Again, the content of the clothes. After the arrest of their clothes, right? Anyway, here, SIM cards was managed within the air. Right? But the incriminating circumstances was formed. A share of events from which a conclusion about the guilt of the accused will be drawn. Right. It is well settled that an offense of conspiracy is substantial and renders the mere agreement to commit an offense punishable. Even if an offense does not take place pursuant to the illegal event. What about all the offenses? Rest of the offenses. The charge sheet is for 120, 200 offense. Right was registered not only for uncognizable but also for cognizable offences. What would take cognizance for 120 and 200 uncognizable offences in the final report that is filed in the case? Against these two petitions, people we got for 1 and 2. But they are committed to the case with the aid and assistance of 120B. What the Supreme Court would say is that they repeated the risk of repetition by inviting my last and last sentences in this paragraph. It is well settled that an offense of conspiracy is a substantive offense. That's what I submitted to your lordship. An independent separate charge is framed for an offense under section 120B. Then allowed in relation to the rest of the offences and charged with the aid and assistance. And renders the mere agreement to commit the offense. And renders the mere agreement to commit punishable. Even if an offense does not take place pursuant to the illegal agreement. That is yet another judgment. What the Supreme Court would say in argument to the Supreme Court with the compilation. Page 61. I request you lot of candidate, paragraph 36. Six. We shall first deal with the third point. The offense of conspiracy is an entirely independent offense. We shall first deal with the third point. The offense of conspiracy is an entirely independent offense. Though other offenses are committed in pursuance of the conspiracy, the liability of the conspirators for the conspiracy itself cannot disappear. Vanish. Because the other offenses are not committed, because conspiracy itself is an independent offense. But down below, in the paragraph from the bottom of the paragraph, 10 sentences about. Not as already stated, when offense were committed, which a conspiracy was entered into have actually been committed, it may not. But in the circumstances of the case, it is desirable to change the offender, both with the conspiracy, charge the offender, both with the conspiracy and the offenses committed in pursuance of that conspiracy. But that would be a matter ultimately within the discussion of the court before which the trial takes place. What point is carrying not only one, even the offense had not taken place before. Independently, it is an independent. So my Lord is persuaded to accept my submission. The trial court to take cognizance of the offense after perusal of the final report, which is the nature of it, not only for various offences that are made in the provisions of the penal code, two such offences being 120B and 201 of the Proceedings. At this stage, as I invited my Lord's attention to one judgment yesterday, we can't appeal to your Lordship to appreciate the events. Look into the documents which are produced in some other cases. But those papers of other cases do not form part of the record of this case. The magistrate had no opportunity of adverting to or looking into those papers. He had the opportunity of adverting to only the evidence which the investigator collected in this case. Beyond that, nothing more and nothing less. So, on the basis of the evidence that is found in this case, after perusal of the entire charge sheet, that is the finding of the court. The magistrate had noticed that there exists a prima facie case to proceed against those to take cognizance of the evidence. But unfortunately, in this case, what came to be questioned is, after the order of taking of cognizance of 191B of the CRPs, I drew my Lord's attention yesterday. A further order is passed under section 204. Our order under section 204 is issuance of process against the accused. Maybe a warrant, maybe a whatever. First stage is of taking cognizance. Second stage is issuance of summons. What came to be questioned is only the order of taking cognizance, not the issuance of summons. The order of cognizance got merged with an order which came to be passed in section 204. Have a look at this criminal petition. Have a look at the prayer column. Prayer column. Criminal petition. Order of issuance of summons is not compared. Okay, this has got merged. The order which can be passed under section 204. In page 7. Therefore, the petition say on a date of more something where the result of the debate to pass the entire order taking, including the order taking cognizance. And the law came to lay down the Supreme Court. I do my last attention to one of the budget. I do not even question the legality and characters of the court of summons issued against them. Therefore, what the question is, the order taking cognizance of the evidence. What is wrong? You find out what is wrong. Validate would say. But he did not write a detailed order. It's just several pages. A cryptic for this section. That order should indicate application of judicial method part of that. That's all. You understand that more than less. That cryptic order indicates the application of judicial mind on the part of the magistrate to the facts of the case. Along the point, the evidence will be investigated, corrected, and brought up in court in the case. But my respectful submission about the case, and I think that the day does not warrant interfere. But yesterday, I invited my lord's attention. May now take your lordship to my compilation of judgments. What I had stopped yesterday. Page 21, my compilation. Well, let's request you not to kindly turn to page 25 now for a second. Page 25, paragraph 28. Look at this. This is in 2022. This is the online SC 820. I don't date page 25. Having gone through the improved judgment in order passed by the High Court, by which the High Court has set aside the city in exercise of the powers 482 is also petition to 482. It appears that the High Court has virtually conducted the trial. We require to repeat these documents. And the interest of the prosecution in that case is a mathematical action and all that. It would do no, can't be done. People can say case, why research. But undoubtedly, this court will exercise the jurisdiction of the Supreme Court and look into the admitted documents. That's a settled legal position that will be fair to the second also. But those documents was first placed into my hands. Say, not upon me, you admit these documents are not. What the CRPC also say, just like the expert opinion of fine expert, then the postmortem report, the forensic science report, and all those things. If I were to admit it, then certainly it is right. And what the Supreme Court just advice. Those documents should go to the root of the matter. Before I come to the Supreme Court. In addition to that, must have an intrinsic value. Karnataka versus state of Karnataka by CID, and what the Supreme Court has said. The documents on which the defense will place reliance when it invokes the jurisdiction of the court of 482 must be number one, admitted documents. Or certain documents which are in the nature of court proceedings, like a client, a judgment. Number two, those admitted documents should go to the root of the case. Three, it must have that's a value. The other case. Like the statements of A and A would say in the tape recorded version, yes, my wife, I said so. I came to be induced. These are two sources. It's often also marriage, money and property to make a false statement against the billing directors. But now kindly go to A, paragraph 58. It appears that the High Court has virtually conducted a minute there, which as such is not permissible, is stayed and while deciding and the application is reported to the CRPC. As observed and held by this court, the category of decisions, no minute there can be conducted by the High Court in exercise of the constants reported in the CRPC. And at the stage of deciding, the application is reported in the High Court cannot get into appreciation of evidence of the particular case being considered. Applying the law laid down by this court, the opposite decision to be facts is fine. And the manner in which the High Court has allowed the petitioner to reported into the CRPC. We are the opinion that the input judgment is not a part. By the High Court, crashing it in the proceedings is unsustainable. High Court has exercised jurisdiction, crashing the criminal proceedings. It also required, noted, that even the High Court itself is required with the allegations of the CDA, and it requires further investigation. That is why the High Court is directed to investigate the CBCID with respect to the affair and response. Even the connected petition required by the Leonard Federer, he has sought further investigation. Investigation in this case is warranted. But now kindly go to paragraph 32 for the part and 6 sentences above. At the stage of deciding the application of this report into CRPC only, and as reply in both cases are yet to take place, we refrain from making any further observations which may affect the case, either the parties. Suffice it to say that the facts of the case, the High Court is very seriously that fraction in setting aside the proceedings. Rising over the cases in this moment. But incidentally, I was inviting my God's attention. The only piece of evidence in all the cases that have come up for consideration for all Supreme Court records. The collection of the all detailed records by the investigator of the two mobile phones of the accused persons who are talking intensely. The Supreme Court so that is more than sufficient to say the constitution is the results. But this in 2021, 8 Supreme Court cases, 583. But where first you like to kindly this is the case in the Sarania's case. Yes, Sarania's case. Kindly tell to paragraph 15. 13. Only one sentence. It also appears that during the course of the investigation, the investigating officer has collected very important evidence in the form on details between A1 and A2, which are in the proximity of the time of commission of offense. Pen drive has been seized. The song being circulated in the social media. The pen drive was also placed in the hands of the investigator. The transcript of it also was part of the record of in this case. That would be the figure. Which not good for the process that is ordered against the proof of their appearance in the case. But after 4 days, cognizance of the evidence. But that's about 4 days back. Supreme Court of the North case. The 4 days. There is the private complaint is the police charge sheet. This is taken at 190. The private complaint is 191A. It is the police report collected 190B. As far as the issuance of process is concerned, under section 204, there is no other provision which the court would exercise jurisdiction as the issuance of summons. Now, you require Deadline is on 5th of October 2023. Just 2 days back. Then the bill, what is the deadline? Paragraph 44. That's when the magistrate takes cognizance of offences. Proceeds under section 200 based on the prima facie satisfaction that a criminal offence is made up. But there is a private. Yeah, a police. There is no question of keeping the section 200 as much as examining the I won't himself have examined the interests and I can't meditate to be to the 162 and 162. Here we have the advantage of those statements. He is required to satisfy himself by looking at the allegations covered in the complaint. The statements made by the complainant in support of the complaint. The documentary evidence in support of the allegations, if any produced by him, as well as the statements of the evidence. Allegations. Although they are not concerned with the issue on medical here, if an inquiry and investigation is conducted therein, it goes without saying that the report should also be looked at by the magistrate before issuing process answer. It did not gainsay that at least the magistrate decided to pass an order summoning the accused. Examination of the nature reported not to be intended to form an opinion as to whether the materials are sufficient conviction. Instead, he is required to form an opinion whether the materials are sufficient for proceeding, as the title of the relevant chapter would indicate. 6. The accused does not enter the arena at that stage. Question of the accused raising a defense to far the issues of process does not arise. You can't that. That's hard. The issues of process. Oh, look at my defense. Nonetheless, the fact that the accused is not before the magistrate does not mean, and it is a cautionary report, does not mean that the magistrate did not apply a judicial mind. Nothing in the applicable law prevents the magistrate from applying a judicial mind to other provisions of the law and assess time with a prima facie and offense as defined in section 20 CRPC. Such opinion being formed on the proceeding as in section 204 does not arise. The first must formulate an opinion. That is what the magistrate has done. I invited the law secretary proceeding of the case today. They use the charge sheet. The documents filed along with the charge sheet. Prima facie discloses the commission of offenses that are made penal as 120B, 201, 384, 360, among other offenses. Therefore, the act the district is the matter. The purpose of passing an appropriate ordinance. What the law imposes on the magistrate and the requirement is that he is bound to consider only such of the material that are not before him in terms of section 200 and 202. Here in terms of section 272, there is a judgment. As well as the applicable provision of the statute, and what is important is the restriction by law giving that is precluded from considering any material not brought on the record in a manner permitted by the legal process. But here, what involved by laws reduced. the jurisdiction article that you put. I would respect the subject matter. More than subject to what we are say.
That is what has been laid on by the Honorable Supreme Court also.
Yes.
Yes.
More than that, Article 32.
Yes.
Fundamental. But the jurisdiction that is involved by the petitions of your lordship is not a problem. As a logical corollary to the above proposal, what policy is the magistrate when deciding whether the issue process is entitled to form review utility materials before him. However, such materials themselves disclose a complete defense under any of the exceptions. Nothing prevents the magistrate upon application of judicial mind to accord the benefit of such exception to prevent the frivolous complaint triggering an unnecessary trial. But the very material that is made available by the investigator to the court itself to disclose the defense which the petitioners have taken before the court, that the magistrate was indeed entitled for this case. The very material should disclose, not the material the accused is going to bring on record in the case. Now, trying to put the next page around. Keep 3 sentences from the top. On the contrary, if from such material, this is very important. On the contrary, if from such materials a prima facie satisfaction is reached upon the application of judicial mind of an offence having been committed, and there being sufficient ground for proceeding, the magistrate will no other better from issuing process. Prima facie case being found, and even though much can be said on both sides, the magistrate will have no option. I did not this. Magistrate will have no option. The requirement of recording the reasons of the state of issuing process is not a statutory mandate. Number 204, he did not give reasons because at the time when he takes cognizance of section 191B, he has said it, all those things. Those satisfied, there exists a prima facie case. So, but again, for the purpose of issuance of process or not as mandate, the magistrate again give reasons. This is also the law declared by this court in Jagdish Constitution of Rajasthan. Since it is not a statutory mandate, the reason should be recorded in support of formation of the opinion that there is sufficient ground for proceeding. Dismissal of the complaint has to be backed by the reasons. In case of dismissal, if he refuses to take cognizance, he must give reasons. Takes cognizance and does not propose to dismiss the complaint, but then no reasons are needed. As an application of judicial mindset. That is reflected in the degree of satisfaction invariably but vary in both the situations. But in order of dismissal, degree of satisfaction is more. But in the case of issuance of process, degree of satisfaction is but in the former is a prima facie satisfaction based on probability of complicity, the later would require a higher degree of satisfaction in that the magistrate expresses final conclusive view like dismissal because of absence of sufficient ground. Now trying to go to paragraph 46. According to the aspect of exercise of jurisdiction by the High Courts under section 482. The case where the offense of defamation, in particular, they are concerned with the case of defamation, is claimed by the accused to have not been committed. But here also he gives a defense. I come and accept this. I come and accept A, B, C, D, E, F, or illustration A, B, C, D, and G. So, law seems to be very certain that the High Court cannot go no further than enlarge the scope of inquiry if the accused seeks to rely on materials which were not there before the magistrate. This is based on a simple proposition that what the magistrate could not do, the High Court cannot do. It cannot be understood to undermine the High Court's powers. Saved by section 482 of the CRPC. Such powers are always viable we exercise X division. It would be able to substantiate justice, but I don't think it alone that it exists. However, the test and exam for fashioning an FIR are criminal proceedings arising from the police report by the High Court in exercise of the jurisdiction under Section 482 of the CRPC, not being substantially different from the test and exam for fashioning of the processing under Section 404, that is Section 200. The High Courts are recording due satisfaction before the interview. For the reading of the complaint, the substance of statements and work of the complainant and witnesses, if any, and the documentary evidence as produced, no evidence is made out, and if it is if allowed to continue to the amount in this. This too would be impermissible. Justice of that not for the So what needs to be seen is yes, with the investigation. Statements of the witnesses, the part of the investigation. The recovery with the investigation make pursuant to the monetary statement made by the accused of the evidence. If they are sufficient to come to a prima facie conclusion, prima facie analysis without ultimately going to go to the past, we cannot be true. But for the purpose of the issues of persons, the exhaustion can lie down. Last but not the least. Irrelevant solutions. Compensation. But most of the time came to be registered. The principal accused in the case came to be arrested. A6. A6 is the one who would enter into conversation to persuade the child A to make a false statement. But there is no difficulty for the investigator to have identified A6. The name is there. The conversation would indicate that he was the teacher of A. And he had an interaction, a conversation with A6. There is no difficulty for it. But here, the complaint is not against the petitioners, but basically it is against A6. A6 name find a place in the complaint. And it forms the basis for the registration of the crime. So A6 no difficulty in identifying. But during the course of the interrogation of A6, after he came to be arrested, A6 would volunteer the statement or give the information about the conspirators for the commission of the crime they be evaluated. It is on the basis of the voluntary statement of the accused, certainly could be used not for recovery, but in furtherance of the investigation of the crime. And the statement recorded in Section 27. Section 27 statement could certainly be made use of for the purpose of recovery or discovery. But here, the process of further investigation, in furtherance of the investigation, but that statement could certainly be made. So what happens is, can you imagine the situation of this nature? A dead body is found laying over the road at a particular place. Some stab injuries, all bleeding injuries all over the body. Your partner back would notice this dead body being found lying with serious injuries. But you would go and file a complaint with these organizations and notice that. Police is bound to investigate crime because the injuries are there. The dead body was found. It primarily disclosed the commission of the crime. So the crime will be registered not against A, B, C, and D. It will be registered only against unknown persons. There were not investigations taken. If during the course of the investigation of the crime, names of the offenders are disclosed, and the evidence with the investigator collected during the investigation discloses the completely of these persons. Isn't that they can't be prosecuted? Because their names do not find a place in the first information report. But probably, even if you had questioned, the petitioner had questioned, the first information report on the spot, that their names do not find a place, your lordship would certainly not have entertained it. Go ahead to the petition and flash the first information report solely on the ground that their names are not. No, their names will be disclosed during the course of the investigation of the crime. And the investigator would lay his hands upon them. He has refused to get sufficient evidence indicating the competency of those persons whose names do not find a place in the document. To get satisfied. That's evidence. That alone is sufficient. Then he would lay his hands upon the document. What is wrong with it? A crime for a cognizable offense has been registered. It is done. He wanted to lay his hands upon him. Least there will be destruction of the evidence that is available, or he could get it after interrogation at his hands. What is wrong with him? As if he has not committed any offense. Can he invite a finding at the hands of this honorable court? No, the petitioners have not committed any offense. Even then, he wants an amount to be awarded as compensation. But it's after the arrest. Yes, the authority. These hands upon any person who is suspected to have committed a cognizable offense. Not that he has committed a cognizable offense, who is suspected to have committed a cognizable offense. Why the compensation? The great thing here then. Well, have a look at section 357 now of the CRPC. When can the court award compensation? Because your lordship, it appears posed the question. And what authority compensation would be awarded? Let me go to section 357 per second. This is the petition and a 482, not a petition. Order to pay compensation. The court imposes a sentence of fine and a sentence including a sentence of death, of which fine forms a part the court payment cost of the judgment order before the refund of fine recovery. They agree. The empowerment, not to the accused. D57 empowers the trial court to award compensation of such amount as it would deem fit and proper, not to the accused. It was a sentence of fine. In the event of the fine amount being recovered, pay or order the payment of such amount as it would be deemed fit and proper as compensation, usually at the last which the empowerment or the witness to the prosecution have such. Thanks.
ಹೇಳ್ಬಿಡಿ ಪರವಾಗಿಲ್ಲ. You have taken lot of time now.
Shall I make?
Yes. Want to leave? Yes, yes.
It not be. That way it is separate.
Yes. Yes.
In the prayer itself, crime number 445 is a. Crime number 445 was registered on 13/10/2022. Like large by mother of the victims. Making allegation of sexual assault, allegation of rape.
What is that crime number?
45. The initial number was crime number 182 of Nazarbath. 182 part 52. Even transferred to Chitradurga Rural Police Station.
Yes.
That became crime number 445 part. The allegation in the FIR. We have heard some social media conversation. It appears on the basis of this conversation, the conspiracy falsely implicate the quantity of the murder in crime number 445. This is the definite allegation. The transcription of the conversation has been read. That also the allegation was that there was some conversation between accused number 6 in this case, and that one of the victims.
With reference to that.
Yes, he was incited to give a complaint or a statement that the quantity for the man has misbehaved with her. But upon which her mother has lodged a complaint. The mother of police is initiated. Upon which FIR was registered. Most important aspect in this case, FIR in 182, then 445 is the subject matter that was under investigation. But as on the date of lodging this FIR, question here, entire argument now, whatever submissions, questions, possibilities, inferences to be drawn like this, that is ultimately is that the quantity of the mud has been falsely implicated by making a false complaint against him. Thereby, he has been imprisoned and proceeding is initiated. For allegation in this case is also the same allegation. Charge sheet is also that. Investigation is also that. This is the version of the accused. Whether there is any provision under the code of criminal procedure, lawfully, when an FIR 445 was being investigated, then an accused set up another FIR of his own account, and police can receive it and investigate that FIR. Is the question, this is the only question in this case. All these are all to ground. This is decided. My submission to Lord that accused my Lord, when he was accused and offense in 445. On this we have not this FIR was. But accused has no right of either lodging complaint, treating it as an FIR. Rule of RDR from Pato will not apply to the accused at all in a criminal case. But once FIR is registered, till charge sheet is filed, the accused has no locus standi to challenge it, particularly with right and authority of the police to investigate. This has been very clearly enunciated in Boko's case, related addition. Even here, the actual circumstances of the case will not be. But they make an allegation that the quantity of the man has been falsely implicated. It's an allegation of rape and sexual assault, principal under IPC, and also mentioning crime number 445 can be police to have registered an FIR. Very authority of the police registering an FIR is to be considered by the
You have relied upon a judgment, yes.
No, this is not, I remember, not two more decisions, not touching on this. Aspect.
Yes.
You have no authority to register the affair. It should have been, it is the subject matter, to be considered by the investigation officer at 4:45. It is the version of the accused. Even now, the entire cry of this, the other side, is the cry of the accused. They have been false implicated. The girl has been prompted to give false version. Once in the court statement is all that. Why they have one to that ordinary mistake? Why they did not disclose? All these questions, my lord, is to be answered by the complainant and the victim and other witnesses in the trial against the in the trial, that is 4:45 trial, my lord. All these questions to be answered by them. The only conversation, my lord, can be at best they use it as a previous statement of the victim or one of the version of yours in this telephonic conversation like this, that you have been incited with someone to give a complaint, what you say. You will have to confront that victim in the trial whether it will go on against the quantity of the man. That is in trial for 4:40. Cannot be basis for registration of FIR. Parallel investigation under the code of criminal procedure is permitted at the instance of the accused. But in this case, it is as if they set into motion a parallel story of the accused, influence the police. Police were maneuvered and asked to register an FIR. They have succumbed to the pressure because at that time even the government messenger was favoring the accused in this. It was stated in that document. It's not that, not that. Why they have gone to that mission, the social organization? All this is because it's home. That is not the subject matter here. The question, the Lord, that since the allegation now, the argument now is the quantity of the murder in crime number 4:45 has been false. Without trial, without the verdict of that court, then the version of the accused be accepted and these accused be asked to face it. Submission the Lord that here the Lord to constitute an offense. Cause of action has not arisen. After the trial is concluded, the trial court comes to the conclusion. No material has come. Deliberately, intentionally, false information was given against the content of the mind. That's how his image, his life has been deprived of go on. Therefore, the cost of this is the person who have been cited or initiated a proceeding by lodging a false complaint to be dealt with in accordance with section 177, 182, even 195 if it is not witnesses of that. My submission is, I did not say that the allegations made in the FIR constitute offense under 177, 182. 177, 182 becomes only on conclusion of trial in 4:45, not before this. No offense has happened now. It has not happened any offense in this case. Very registration of FIR will not assuming to be of some offenses. 384 here on a person. Conversation transcription was read out. No fear was put on that conversation on that victim. You give any information against the quantum of it. 384 does not track. 3,50,000 rupees for mortgage of a house was given to complainant before lodging this complaint. That do not constitute any offense of the 384. 420 is dropped now. 420 cheating is also dropped. The mobile phones are seized. First of all, prosecution has to show using of these mobiles for the commission of the offense. Then destroying of evidence arises. The two mobile phones seized at the instance of these two petitioners are not proved to be used in the commission of the offense. How can the question the law arises of destroying of evidence? My submission will not be answered. But the very registration of the affair is illegal. Why does it issue? You are part 195, I am not gone to the state. These are all very controversial, not at best in the Lord. On conclusion of trial, their case may, allegations may come to that stage. But at this stage, no offense has arisen, no cause of action has arisen. So I relate without one of the decision of Supreme Court. This was that the accused has any time at this stage in the investigation, he is being taken up on top. They cannot develop another parallel story. If that is allowed, it's a mockery of criminal justice. One a victim will lodge a complaint and the accused will lodge another complaint. Parallel investigation, simultaneous trial. But one aspect will not be very important in criminal justice, or even in civil matter. Fact is, positive fact to be proved. Yes, Pontiff of the Mutt has committed rape against some victim. Cannot be investigated. Pontiff of the Mutt has not committed rape. Only positive to be investigated, not negative to be investigated. This is how the Lord does. Negative cannot be asked to be proved. They are asking negative. When positive allegation of commission of sexual assault was being investigated, they cannot settle the theory that you investigate, I did not do it. For them to prove in the crime, police has no authority to investigate. The very jurisdiction of police may not be questioned here. I read to you, Rashid, that state is still Antony's case. Police station to the officer in charge of the police station that I have been victimized, I have suffered loss, I have been imprisoned like that. If you see it, apply his mind whether it constitutes an offense of cognizable nature or the registration of the FIR or not. So subjective satisfaction under one's people is very important. That is, when I give it to an officer in charge of police. That officer in charge of police in this case, when crime number 445 being mentioned in the complaint, the body of the matter has been also implicated on it discloses in the conversation. You have been treated as a part of a document to be considered by the investigation. The registration of the FIR is illegal. If registration of the FIR is illegal, on the basis of this illegal FIR, whatever material collected has to fall on ground. It is all illegal material. Charge sheet is also illegal material. It cannot be given any consideration. Now, kindly see the Lord that this may not be treated as an FIR in respect of same allegation. Second FIR is not permissible under law. Only one FIR will not have first information is to be registered. Whatever may not subsequent allegation petitions come the Lord, even as a complying to the officer in charge of the case, they become part of the record of the first case. In the first case, while considering the Lord investigation, while conducting investigation, culminated with police report, the investigation officer has adverted to this complaint also, and he has concluded that it has a counter blast. Not ignoring. Yes, he has concluded that this is also a case of counter blast. Not a counter case. They have realized some of the authorities with regard to case and counter cases, not argue that only clarification. Case and counter cases arises only both sides injured are there. Both sides claim victims. Then case and competency. In this case, one side they are claiming, Gayatri claiming my daughter has been subjected for sexual assault. She is a victim. The other side claiming the Lord on behalf of Swami. Pontiff was innocent. Innocent to be determined by the verdict of court, not by the defense argument. They may say, yes, always. Accused always say, his stand of defense will always be total linear. That should be determined by virtue of a judicial process. Therefore, not accused version cannot be taken during the course of investigation. This is prohibited. Except to the extent that the person who is arrested, he can be questioned, his voluntary statement can be recorded to the extent of recovery leading for discovery of fact, or he not to the satisfaction of purpose of investigation. That is a part of investigation. But investigation process, that is registering one more require and going for investigation, accused have not committed an offense, is unknown to criminal law. Since not that I relate, who listen to not say it. Today's compilation, page 55, this place is and page 85. This 85 paragraph 88. The principle of law that could be deduced from the above decisions is that it is no doubt true that the fact that the decision, whether a prima facie case has or has not been made out, is not by itself determinative of the exclusion of hearing, but the consideration that the decision was purely an administrative one and full-fledged inquiry follows relevant. And indeed, a significant factor is deciding whether at that stage there ought to be hearing, which the statute did not expressly grant. Mainly about principle, it may be held that when the investigating officer is not deciding any matter except collecting the materials for ascertaining whether a prima facie case is made out or not, and a full inquiry in case of filing a report under section 172 follows in a trial before the court or tribunal pursuant to filing of the report. It cannot be said that at that stage, rule of adi alternam partem superimposes an obligation to issue a prior notice and hear the accused, which the statute does not expressly recognize. But this is not that. The question is not whether adi alternam partem is implicit, but whether the occasion for its attraction exists at all. The scheme of chapter 12 of the Code of Civil Procedure, there are various provisions under which no prior notice or opportunity heard is conferred as a matter of course on the accused person, while the proceeding is in the stage of investigation by a police officer. State of it is investigation is not a bilateral process. In a civil matter, there will be a flying, there will be a written statement, there will be claiming of issue. In a criminal case, they discuss that how important in the criminal case is. In state of Haryana, such present law is to both of us were parties of the making of the edition of the constitution before us and Matira was. In addition of this court in state of Bihar, J. Saldana has pointed out that the field of investigation of any cultural offense is exclusively within the domain of investigation agencies. over which the court cannot have control and have no power to strictly or infringe upon the proceeding. In the investigation, so that as the investigation proceeds in compliance with the provisions relating to investigation. Also, the accused has no right to have any say. No right to have any say as regarding manner and method of investigation, save under certain exceptions, under the entire scheme of the court, the accused has no participation as a matter of right during the course of investigation of a case instituted at a police report till the investigation culminates in filing a final report on the section 172 of the court, or in the proceeding instituted otherwise than a court report will the process show under section 204 of the code as the case may be. Even in cases where cognizance of offense is taken and complaint, last findings that said offense relevant magistrate are read excluded by the court of session, the accused has no right to have participation till the process is issued. In case the issue of process is postponed, as contemplated under section 202 of the code, the accused may attend the subsequent inquiry but cannot participate. There are various judicial pronouncements to this effect, but we feel that it's not necessary to recalculate your decision. At the same time, we would like to point out that there are certain provisions in the report empowering the magistrate to give an opportunity of being heard under certain specified circumstances. It may be noted that under section 227 of the code dealing with discharge of accused, he gets a right only an audience in the court to urge for discharge. Apart from approaching this court, either under the article 482 is different. In the ordinary course of as per the procedure prescribed under the code of procedure, accused have no right of audience till the matter reaches for discharge stage. This is what we learned in this section. It may be noted that under section 227 of the code dealing with discharge of an accused in a trial before court of sessions, under chapter 18, the accused is to be heard and permitted to make his submission before the stage of filing of the charge. Under section 228 of the court, the trial judge has to consider not only the records of the case and documents submitted therein, but also the submissions of the accused and the prosecution made under section 7. Similarly, under section 239, falling under chapter 19 dealing with trial of foreign cases, the magistrate may give an opportunity to prosecution and the accused of being heard and discharge the accused for the reasons recorded in the case. The magistrate considers charge against the accused groundless. Section 240 of the code dealing with breaking of charge about the consideration of the examination of the accused under section 239 before the charge is made. Under section 235, may not hear the last of the kindly, accused will be called upon to enter for defense. Section 232, 235 is the state that after the trial is over, accused will be called upon to enter for defense. Then his right to meet whatever evidence arises. This is under section 235(2) in a trial before the court of session, and under section 248(2) in the trial of foreign cases. The accused as a matter of right is to be given an opportunity of being heard. Unlike the above provisions which we have referred to above, way of investigation, provisions related to investigation of the applicable do not confer any right of prior notice and hearing to the accused, and on the other hand, they are silent in this respect. No provision of law, right from 154, all provisions up to the law 225. It is read in the law, there is no scope for the accused to insert anything. But it is relevant and significant to note that a police officer in charge of a police station or a police officer making the investigation can make a search or cause search to make for the reasons of the recorded without any warrant from the court or without giving prior notice to anyone or any opportunity of being heard. The basic objective of such a court is to preserve secrecy in the mode of investigation, lest the valuable evidence to the other will be either destroyed or lost. We think it unnecessary to make a detailed examination of this aspect, except saying that an accused cannot claim any right of prior notice or opportunity of being heard, including of his arrest or search of the resident or seizure of any property in his possession connected with crime unless otherwise provided in the law. 2. There are certain rights conferred and accused to be enjoyed at certain stages under the code of the procedure, such as section 50, where under the person arrested he should be informed of the grounds of error, his right of bail. Under section 57, dealing with person arrested not to be detained for more than 24 hours. Under section 167, dealing with procedure, the investigation cannot be completed in 24 hours. These are all is confirmed with the right to life and personal liberty enshrined in Article 2 of the Constitution and the valuable safeguards enshrined in Article 2 of the Constitution for the protection of an arrestee or deputy in certain cases. But this next is very important to us. But so long as the investigation agency proceeds with its action or investigation in strict compliance with the statutory provision relating to arrest or investigation of a criminal case, and according to the procedure established in the law, no one can make any legitimate grievance to stifle or to impinge upon the proceedings of arrest or detention during investigation, as the case may be. In accordance with the provisions of the code of but when 445 was being investigated, another member parallel proceeding on the trial of accused that I am innocent, I have been falsely implicated, resisting an FIR, no provision at all. This decision has been referred only one sentence in the law in a recent decision and which over this case also. Previous stage in the law also, they say it's 15 the law. See again in the law the same principle it has been reiterated with more strong words. Supreme Court has criticized the role of accused if it is given administration of criminal justice before to justice. This point, criminal justice system will be for protection of society, not for the accused. Accused has a right to defend himself in accordance with the procedure established in the law. Ultimately, the law it is the state which takes the action, not the individual. It is not a fight between individual person. It is the responsibility of the state to protect the society and punish a guilty person. What is the procedure? Procedure is under the code of procedure. Section 4 the law, Lakshmi kindly says that all the inquiry trial to be conducted is hereafter contained under the code of beginning section itself. Here I take you Lakshmi page 49 the law, previous page 49 paragraph 31. This is also the second FIR was released. Second FIR, except in a case and counter case, not permissible. This is the law as of today. In this case also, that is the law. Paragraph 31.
Yes.
The rule of ordinary exception. Such exceptions may be provided by law or by such necessary implication where no other implication is possible. The rule of natural justice has an application both under the civil and criminal jurisprudence. The laws like detention and others especially provide for post-detention hearing. And the settled principle of law, the application of this doctrine can be excluded by exercise of legislative powers, which shall withstand judicial scrutiny. That should be not that in the preventive detention matter, advisory bond accused will be taught, right of hearing, right of representatives. These are all the scope specifically provided under the statute, under the preventive detention. But under the code of criminal procedure, there is no scope calling upon the accused, here upon him, accused ಮಾಡಬೇಕಾ ಏನ್ ನಿಂದು right of audience melody is not there at all. This will what it is. The last like melody, the effectively execute the effective purpose of criminal procedure code and penal code 1860 is to effectively execute administration of criminal justice system and protect society from perpetrators of crime. It has a twin purpose. Firstly, to adequately punish the offender in accordance with law. Secondly, to ensure prevention of crime. On examination, the scheme of the criminal procedure code does not provide for any right of hearing at the time of registration of the first information report. As already noticed, the registration forthwith of the governor levels is the statutory duty of the police officer in charge of the police station. The very purpose of fair and just investigation stand frustrated. The pre-registration hearing is required to be granted to the suspect. It's not that the liberty of an individual is being taken away or is being adversely affected except by due process of law. Where the officer in charge of the police is informed of the goodness of conduct, it will completely destroy the purpose of proper and fair investigation. If the suspect is required to be granted the hearing at that stage and is not subject to custody in accordance with law, there will be predominant possibility of suspect escaping the process of law. The entire scheme of the court unambiguously supports the theory of exclusion of body or part of pre-registration of an FIR. Upon registration of FIR, the person is entitled to impose the various provisions of bail and answer. Line is regarding according to law. Cannot be said to be a violation of the principle of natural justice for two different reasons. Firstly, it does not provide for any such right at that stage. Secondly, the absence of such a provision clearly demonstrates the legislative intent to the contrary, thus necessarily implies exclusion of hearing at that stage. The decision of W.N. Chadda's case, not proposed case, has been extracted. And I directly go to paragraph 33 of that. Samaja Parivartan's case is also in paragraph 32. This contribution, finding this para 32 also. The judge bench of this court by dealing with the right of hearing a person having a suspect or likely offender in the report of the CEC observed that there was no right of hearing. Though the suspects were already introduced in the declaration, they were heard. Stating the law in regard to right of hearing before that, and there is no provision in CRPC where an investigation agency must provide a hearing to the department before registering an FIR or even before carrying an investigation prior to registering of the sales against the suspect. DBA has already noticed may even conduct pre-registration inquiry for which notice is not contemplated and the provisions of the police manual or even as per the incidents laid down by this court. Only in those cases where the court directs initiation of investigation by a specialized agency or transfer investigation to such agency from another agency, the court may miss discretion grant hearing to suspect of the party. However, that also is not an absolute rule of law and is primarily matter with judicial discretion of the court. This question is of more relevance to present case as we have already had the conclusion. When examining the above stated principles in conjunction with the scheme of the court, particularly section 154 and 153 of the court, is clear that the law does not contemplate grant of any personal hearing to a suspect who attains the status of an accused. This word is who attains the status of an accused. Suspect is different. Once his FIR is registered, his name appears in column 2 of the FIR. He attains the status of an accused. But so only when a case is registered for committing a particular offense, as the report under section 173 of the code is fine, helping the suspect and accused that his rights are affected in terms of the court. His life is taken away by virtue of procedure established in the code of criminal procedure, which is permitted under Article 15 of the Constitution. No person's life or liberty can be taken away except in accordance with the established law. Procedure established by law is Indian Penal Code, Code of Criminal Procedure. During the course of investigation, by virtue of this procedure established by law, the life and liberty of the person who committed, who perpetrated the crime has been taken away. Offense of specific provision requiring granting of hearing to the suspect and the fact that the very purpose and object of fair investigation is bound to be adversely affected if hearing is insisted upon. At that stage, really supposed to do that hearing is not any right of any suspect at that stage. Even in cases where report under section 173 of the code is fine, in the court, an investigation records to name a person in column number 2, or even does not name a person in an accused at all. What in exercise of power vested in 390. Then some person has been accused. Even at the stage, summary, no hearing is contemplated. So now, my lord, legal procedure. Now, in substance, my lord, the allegations made in the FIR that our person has been falsely implicated. False information. Please take us. The cry of an accused, unheard of. Law does not support for it. Yet this police will not have abused and misused their power of investigation. They ought not to have received this kind of. Even if it had been received, it should have been a part of the investigation that was going on, not registering a separate FIR. The next aspect, my lord. Charging, my lord, in this case, fine. Certain statements are recorded. Statements are recorded, my lord, in the month of December. This FIR was registered on 9/11/2022. Arrest was made at midnight on 10/9. Accused number 6 was arrested at 00:30 hours on 10/9/22. At 00:30 hours, 2 a.m. Mellon, this first petitioner was arrested. By then, Mellon, he was not named an accused. The reason, Mellon, here, this will also get Mellon in the remand application that I pointed out at page 20. The arrest was effected, Mellon, that page 21, Mellon, 10/11/22, Bedigin Java 00:30. A6 Mellon was arrested. A6 Nasuraj was arrested at 00:30 hours.
No, we are not concerned with the A6.
Not concerned with Rashid, that is,
Yes.
he was arrested 00:30 hours.
Yes.
Because he was named in the FIR.
Correct.
In respect of this petitioner, first petitioner,
Yes.
he was not even named in the FIR.
Correct.
Investigation also was not disclosing his name as one of the accused, and there is no allegation in the complaint. It brought to Rashid time only the petition of.
When was he arrested?
Within about 1.5 hours after the A6 was arrested, night in the Lord at 2 a.m. This will actually gets in the Lord at page 21 of the petition. 2 hours.
On 10/11.
Yes, 10 intervening night of 10 and 11 night.
A1. That is a petitioner number 1. Petitioner number 1.
Part of petition. Part of it. Kindly, previous pages. First part of it.
Yes.
Page 21.
Yes.
Here, page 21, the progress of investigation in this remand application is mentioned. No evidence was collected about the participation of this. Para 9, second paragraph. Dinaka 9/11, 2027 ಈ ಪ್ರಕರಣದಲ್ಲಿ A1 ಆರೋಪಿ ಬಸವರಾಜ ದೇವರು ಎನ್ ಪ್ರಕಾಶ್ ಅವರನ್ನು ಪತ್ತೆ ಮಾಡಿ ಹಾಜರುಪಡಿಸುವ ಸಲುವಾಗಿ ಶ್ರೀ ತಾರಾನಾಥ್ ಸೋಮಶೋ ಸಿಬ್ಬಂದಿ ಅವರು ಆರೋಪಿ ಬಸವರಾಜ ದೇವರು ಪತ್ತೆ ಸಲುವಾಗಿ ನಿನ್ನೆ ದಿವಸ 9/11/22 ಗಸ್ತು ಮಾಡಿ ಆಸಾಮಿಯ ಹಿಡುವಳಿ ಬಗ್ಗೆ ಖಚಿತ ಬಾತ್ಮಿ ಪಡೆದು 9/11/22 ಸಂಜೆ 7:30 PM ಸಮಯದಲ್ಲಿ ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ಅಥಣಿ ತಾಲೂಕು ಗುಂಜೋಳ ಗ್ರಾಮದಲ್ಲಿ ವಶಪಡಿಸಿಕೊಂಡಿದ್ದು ಈ ದಿವಸ ದಿನಾಂಕ 10/11/22 ಬೆಳಗಿನ ಜಾವ 00:30 AM ಸಮಯದಲ್ಲಿ ಗ್ರಾಮಾಂತರ ಠಾಣೆಯಲ್ಲಿ ನನ್ನ ಸಮ್ಮುಖ ಹಾಜರುಪಡಿಸಿದ್ದು ಸದರಿ ಆರೋಪಿ ಪೂರ್ಣ ಹೆಸರು ವಿಳಾಸ ಕೇಳಿ ಹಿರಿಯರಾಗಿ ಬಸವರಾಜನ್ ದೇವರು ಹಾಗೂ ತಂದೆ ಪ್ರಕಾಶ್ ಎಂದು ಜನ ಪ್ರವಚನ ಕೆಲಸ ದಸ್ತಗಿರಿ ಕ್ರಮಗಳನ್ನು ಅನುಸರಿಸಿ ದಸ್ತಗಿರಿ ಮಾಡಿರುತ್ತೇನೆ. ಆರೋಪಿಗಳು ದಸ್ತಗಿರಿ ಮಾಡಿದ ಬಗ್ಗೆ ಆರೋಪಿಯ ತಾಯಿ ಮಹಾದೇವಿ ಪ್ರಕಾಶ್ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ನಂತರ ಆರೋಪಿ ಸಚಿವಾನಂದ ದೇವರವರನ್ನು ಕುಲಂಕುಷವಾಗಿ ವಿಚಾರಣೆ ಮಾಡಿ ಆತನ ಸೂಚಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಪ್ರಕರಣದಲ್ಲಿ ಎರಡನೇ ಆರೋಪಿ ಸ್ವೇಚ್ಛೆ ಹೇಳಿಕೆ ಆಧಾರದ ಮೇರೆಗೆ ಒಂದನೇ ಆರೋಪಿತರಾದ ಬಸವರಾಜ ಎಸ್ಕೆ ಅವರ ಪತ್ನಿ ಸಲುವಾಗಿ ಈ ದಿವಸ 10/11/22 ಬೆಳಗಿನ ಜಾವ ಕಿರಣ್ ಕುಮಾರ್ ಸುವಂಶು ಆರೋಪಿಯನ್ನು ಈ ದಿವಸ 10/11/22 ಬೆಳಗಿನ ಜಾವ 1:30 AM ಸಮಯದಲ್ಲಿ ಚಿತ್ರದುರ್ಗ ನಗರದ ಮರಳಪ್ಪ ಬಡಾವಣೆಯಲ್ಲಿ ವಶಕ್ಕೆ ಪಡೆದುಕೊಂಡು ಈ ದಿವಸ ದಿನಾಂಕ 10/11/22 ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಕುಲಂಕುಷ ವಿಚಾರ ಮಾಡಿ
This petitioner number 2 was arrested on 16/12.
On 16/12, then she was also not treated in FIR. Not only in FIR, progress of investigation also her name was not there. The reason, my lord, why I think this was the public motive and modified reason. That in respect of previous cases, that originally which was registered on the basis of welfare officer of Mysore. That crime number first was registered 145, that was registered into 387 of Chitraduga police station. Or that also one more similar FIR was registered against this petition. That is crime number 385, my lord. That was registered, and in that FIR, my lord, since he was named, and he appeared before the magistrate and taken bail. Because his name was there in the FIR, he taken bail. Now, how to arrest him? How to fix him? How to put him in jail? My lord, this is the lord, it is go out, my lord, the group was working against him. Police was supporting for them.
Whose complaint? On whose complaint?
The accused Rashmi, not that she was a warden. She is accused number 2 in the first case. She lodged a complaint against this petitioner, these two petitioners. This your lordship gets in the court FIR at page 8. It's 36 years. This was registered on the very day. The FIR was lodged in Mysore.
Only against petitioner number 1 or both?
Only two were made. Still allegation.
Yes.
This is second FIR again. The Russian candidate page 36.
Yes.
But FIR for offences under section 341, 342, 363, 123, 344 years, 502, 506, 34. All these offences, my lord, are bailable offence. The key, my lord, they appear, they took bail. The allegation is same. 24/7, these two petitioners have brought those two girls taken to their custody and prompted them to lodge a complaint against them. FIR is not registered. And this FIR was lodged by an accused in that case. It is the version of the accused again. This was the first FIR.
Yes.
But this FIR so far not investigated. Because their intention to put him in jail got frustrated, they left like that. This reminds me not the stage of FIR.
What are the complaint?
Complaint may not that the two girls who were found in Karnataka police station were brought to their custody. They were prompted and nice to give a false complaint against Monty of the Met and also the warden of the Met, that is the complainant person. And whether they have been falsely implicated in the first cases. This is the same allegation in respect of the first case. And like in this case, my lord, what now it is challenged for the lordship. It is in respect of second case upon the complaints of Gayatri, which was registered to crime number 4.
Yes.
Now the subject matter, my lord, only here simple, my lordship. Then the petition was submitted to an officer in charge of the police station. That our persons are falsely implicated upon a false allegation. And these some persons are there.
When trial number is mentioned, they can be registered in FIR. There is no scope for registration of FIR under the CR. I draw your lordship's kind attention to application of section 177 and 182 on the basis of allegation only after the trial happens. As of action itself has not arisen, commission of offence is not there. The commission of offence arises only on formulation of opinion by the trial judge. These persons are false. As of today, no offence is committed to these witnesses, including the Lord named persons in the trial. We are not mentioned here, but it is very clear that commission of offence should be there for registration of the trial. Like 384 doesn't apply, 420 we have got. That is 120B is argued that 120.
There is a conspiracy. Yes.
This interpreted, I don't let it dispute that conspiracy is an independent, no doubt. Conspiracy to commit criminal offense. Section 120 definition itself there. This court has considered this. It is substantially offense to the law. The allegations made in the FIR do not constitute any offense. No conspiracy occurred. You are both person agree to do or act which is illegal. The illegal means to commit a criminal offense. That is, this word is not there in the proviso to section 128 definition. Criminal offense is not committed here. That is, if the offense is not committed, even conspiracy to commit an offense. Even conspiracy to commit an offense does not constitute on the basis of allegation. Because the allegation is it is the crime of the accused. It will not constitute any offense. Particularly that charge sheet in all the
Any
cases.
judgment you are relying upon that one, for that one?
The Lord, that's the recently, the other decisions, the Lord, but this Dowlett Crown's case had been recently considered by the Supreme Court. 2017, the Lord. Also, it is the Lord where considering the Lord was initiated upon a complaint lodged by a person which was found to be false.
Dowlatram, you already given that. Dowlatram.
Dowlatram had given the Lord.
Yes.
Decision the Lord following Dowlatram. First decision.
Saloni Arora.
Yes, Saloni, not Arora state.
Yes.
This you also kindly see. But paragraph 9 below. As rightly pointed out to London Council for Competency, on the strength of law laid down by this court in Dowlatram state of Punjab, that not it's mandatory to follow the procedure prescribed in section 195 of the code. Else such action is rendered void ab initio. It's opposite to reproduce the opposite to reproduce the law laid down by this court in Dowlatram, which reads as under the last sentence melody is without jurisdiction ab initio. That is melody already read in melody. This Dowlatram's case principle laid down. It's not in dispute that in this case, prosecution while initiating the action against the appellant did not take recourse to the procedure prescribed under section 195 before. It is for this reason, in our considered opinion, the action taken by the prosecution of the appellant is so related to the offense under 182. This consent is rendered void ab initio, being against the law laid down in Dowlatram above. This case, that stage has not occurred. In case, like now, charge sheet stands against them. They say that they have challenged and the court it. What Lord please? What's the Lord? Even then, Lord, this remedy will not be available for prosecution or the state.
Unless the trial goes on, there is a finding given by the
Finding on the 340 or any other provision, Lord, false evidence has been laid against the innocent person. That court has to formulate a complaint in writing. Question of here we are not cognizant of non-cognizant of. No offense has arisen in this case. The next edition also the law will be same version. That here also the offense of 182 was alleged. The lawsuit held that may not comply in writing is mandatory. Kindly good case in the was concluded that information not was false information. Therefore, when proceeding was initiated, condition was recorded that protection of women from domestic violence and proceeding was initiated falsely. That it was found to be a false information. When the proceeding under 182 was initiated, it was sustained by before Supreme Court paragraph 15 million. Accounting case under section 182 following in details not true. And information was given to a person to public servant. Information was given to a person who knows or believes such statement is false. Such information was given with an intention to cause or knowing to likely to cause, or such public servant who do or not to do anything in the true state of affairs respecting which such information is given was born by him. Or to use the lawful power of such public servant to injure or announce of any person. Present case, the investigating agency has failed to show that the appellant has given information which he was knowing believing to be false. So far, my lord, there is no such finding at all here. At least, my lord, the investigation officer, when he filed a charge sheet, he has not concluded the proceedings initiated against those wanting to be made is found to be false. Therefore, this FIR, this charge sheet maintains only stated that false allegations are there. This is condition precedent. Finding to be recorded in the first case, my lord, that they have been falsely implicated, acquittal to be recorded, and recommendation for decision proceeding and the court. The recently, my lord, with regard to 384 is concerned. Next decision, my lord, is 2023 with regard to scope of 482. 383 extortion provision has been considered, my lord. In this decision, how the police will cooperate for misuse of provisions of this section. It has been considered that proceeding has been quashed. Kindly see page 10 in Shalu Salim. But there also not in identical case. 384 was invoked. Extortion was invoked. There was no theft or put any fear to extort money. The leaders of extortion will not that any person should be put in fear. Don't subscribe to the amount and take your life. You will be killed or your property will be burst. Such kind of threat will not attract only extortion. Those ingredients are not there. Here, what is ready is I had taken 3,50,000 for first petitioner for the purpose of hardship. There was no threat at all to her. The ingredients of 384 does not apply. Paragraph 55, only one paragraph. Previous paragraphs number 383, 386, extortion provisions are extracted.
Yes.
Paragraph 55, thus it is relevant to note that where the first informant has stated that out of here, she paid rupees 10 lakh to 80%. To put it in other words, there is nothing to indicate that there was actual delivery of possession of property by the person putting fear. In the absence of anything to even remotely suggest that the first informant contact with a particular amount after being put to fear of any injury, no offense in section 86 of IPC can certainly have been made up. But this will not extracted the principles of Provisional case. The next page about that is a landmark judgment state of brain of Provisional. Plus 7 principles parameters page 21. These 7 parameters, all these 7 parameters it attached to no offense constitute, no cognizable offense. Complaint do not disclose commission of any offense. Even charge sheet also do not disclose commission. The allegation is full mukaddame dakal sitare. This is the version we got. The police have no authority to say another proceeding is false. It is the court which has to determine false or truthfulness by virtue of a judicial verdict. In this case, the other argument is in charge sheet cognizance has been taken, Charge sheet is filed, cognizance is taken, proceeding is started, it cannot be settled at this stage. One decision will not advise is, will not sufficient in the scale in what the kindly. This 112. 112 will not in this. 11 page will not 122, paragraph 21 will not. The criminal trial cannot be allowed to assume the character of fishing and rowing inquiry. Not be permissible in law to permit the prosecution to linger, live, and continue on the basis of mere hope and expectation that in trial some technical may be found to implicate it. Such a course of action is not contemplated in the system of criminal jurisprudence that has been evolved by the courts over the years. The criminal trial, on the contrary, is contemplated only on definite allegation, prima facie establishing the commission of offense. That has been proved by leading unimpeachable acceptable evidence in the course of trial. We are therefore conclude that criminal proceeding in the present forum and all the allegations level clearly not maintainable against either of the offending accused. Next edition will not that accused have a right of discharge. That is not a ground to deny the scope of 93 will not pay 145. The decision will not that in this August only, where an application for discharge was pending for the trial. Even then, I could has a power under 482 or under article. Discharge accused. This will not in this paragraph 2. The same argument was argued in this case, page 131, paragraph 7. Paragraph 7. Mr. Lalit, when I counsel for the second respondent, that the appellants have already filed an application in the court of additional judicial magistrate for discharge, and this court should not interfere in the criminal proceeding which are at the threshold. We do not think that on filing of any application for discharge, the High Court cannot exercise the jurisdiction under the court. In this connection, reference will be made to two issues of this court in Webster versus Special Judicial Magistrate and Ashok Chaturvedi versus Appeal Heads, wherein it has been specifically held that both the magistrate trial judge has jurisdiction in this stage of the trial. It considers the charge to be groundless, but that does not mean that the accused cannot approach the High Court under section 482 of the code or article proceeding for against them, then no offense has been made out against them. Still, why must they undergo the approval in the trial? Section under section 482 of the code has to be exercised. Great care in exercise of the High Court is not determining the matters superficially. It is to be seen the matter which is essentially the same matter. Has been given a crop of criminal proceedings are not a sort of other remedies other than before criminal court has necessarily take deal of part, but the accused is a serious matter. This court has made some principle and the under this section has to exercise to prevent abuse of or other cases taking the answer. Now, the next mission also not to this case. Just 146 million. Paragraph 29 million. The magistrate in discharge accused that many states of the trial consider the charge to be groundless. That does not mean that the accused cannot appeal the High Court unless the court of the court or article of the Constitution. While the proceeding was against him, when the complaint does not make up any case against him, and still he must undergo the economic impact. Was admitted for us on behalf of the state that in case we find that the High Court will exercise the jurisdiction, it should be remanded that we consider the complaint and the evidence of the court did not make up any case. The record will include definitely the victim has come to conclusion though without any material that in the present case cannot be said at this stage that
So observed and inherently improper, and in version of which no prudent man will never reach this conclusion that there exists no significant ground for proceeding. I do not think that High Court was correct in coming to such a conclusion, and coming to that, it has foreclosed the matter from the magistrate level, as the magistrate will not give any different conclusion on application for the therefore, the High Court will not disavow court and ample power. That requires the proceeding which is an abuse of process for law. With regard to 120B, my lord, this court, my lord, according to bench, my lord, has considered that only one sentence I take, my lord, page 169. Regard to constituting of offense of conspiracy. Paragraph 13, my lord.
Yes.
Then in the argument that section 123 of LPC is independent offense. Therefore, last when we tried that independent of section 420 LPC, it's certainly not there. For arguments, still the accused can be prosecuted for offense of the 123. In this regard, we have placed reliance on the judgment of ordinary of this court in the case of so and so. There is no second word with regard to this argument that section 120 is independent offense. But to invoke this offense of conspiracy, as has been argued by Procedural, the allegation found in the charge sheet must constitute an offense in connection with conspiracy alleged. The offense, the charge sheet will not constitute an offense. 120B will not constitute an offense. 120B should be for the commission of a criminal offense. Which is a criminal offense? There is no criminal offense here. But this will not, the negative aspect cannot be asked to prove. This will not has that recently. This is the decision of the 90. Not the relevant page will also the 90 page 188. Court cannot insist on a person to be negative. Second line. Court cannot insist on a person to be negative. That is accused may not have been fixed with a negative allegation. They have filed false complaint. And the version of the accused they have not committed yet. On the other hand, charge sheet is there, they have committed yet. Both will not run together. And this has been the principle will not 1972 Supreme Court also. One decision page 197 is also decision where complaint do not disclose the name of people. They have not been named at all. It is an abuse of process. The Ramesh Chandra because has taken page 197. Complaint and discharge does not disclose any other people. All the participation and the proceeding price. Relevant paragraph. The machine have considered all the decisions. There are 18 about after relying the Lord Badana state. They do not do election. Not do not 18 para. Other cases to be covered by categories 1 and 3 are enumerated. There are Badana and others as a Badana. Where pollution of compliant and mixer sector came to minister of ministers of the second respondent does not disclose any of the present complaint. Their participation in the commission. They are neither concerned with the nor the latest therefore, not these petitions in this case also the last decision of coordinate bench police will misuse their power and courts of sections. That should not be taken. The contents of allegation made has to be taken note of. Because in this case, some unattractive provisions were quoted in the FIR that was sought for washing the law. This honorable court had the occasion to consider this similar case. Here, 120B, 384, 420, 363A, exactly for the purpose of subjecting a woman or a minor girl or illicit intercourse with another person is engaged, that was quoted in police. There is no such allegation in the police. This is not a camouflage on the part of police. We know the province of these non-available offences, see that this person is arrested and put to jail. This is right from the inception, my lord. There was a qualified intention, ill motive to implicate this petitioner and see that he is put in jail. Now, in the proceedings of this law and criminal proceeding, he has been charged. And submission is that take down files should be go which are led by arrested. There is no dispute. But in all the decisions that led, they were all the files. I say whatever my lord I do, they are it is. Question my lord, if it does not constitute an offense, it is most of an abuse of it. That this honorable court has to cover the whole. The same issue. And they are not the persons who have given a statement. One given statement also not given against them. How can they falsely impute? No, conspiracy should be prior to commission of it. Conspiracy should be prior to this telephonic conversation. Any person agrees to do an act which is illegal by legal means must be prior to this telephonic conversation. There is no material. Somewhere these petitioners have joined the accused number 6 and victim girl prompted them. Or they can say, "He can model no evidence at all. Go for it." It's not. I say that. The prayer is not the entire question. Not don't need to specifically about that. Our prayer is not first prayer is partly applies. The prayer goes to all consequences. Don't need to keep for washing off or set aside the order of issuing of rules. That is there is no order at all.
Reserved.
There is certain areas that but now the new direction has got to be given by the other plan. But the certain new direction is got to be given by the other.
Nothing.
Kindly hear me out for 2 minutes.
Yes.
Kindly hear me out.
Yes.
Look, I am Swami, but I am not accused. You not kindly. I make it very clear. The petitioner in the connected matter and the respondent in the senior counsel matter is not an accused.
Yes.
He is not an accused.
Correct.
And nobody under the criminal justice system can be prevented from bringing certain action before the law enforcement agency.
Yes.
Because as a the person who have come across the various the social media activity, it was my duty to brought it to the notice of the police. I have brought it to the
Yes.
Plus, the senior counsel has repeatedly said it is the cry of the accused. Accused is not before this court. The 445
You have taken the cry of the accused and you are trying to. That is the submission. That there cannot be any doubt about that. Because that is your complaint. That is your complaint.
No.
Then what is it?
That is not my complaint.
Then
I am the GPA holder. This honorable court, sitting under the jurisdiction, permits the party who is in the judicial custody to execute the GPA in favor of the present petitioner.
yes.
To exercise certain acts.
Yes.
This court permits and accordingly GPA.
Yes.
That does not mean that I was carrying the lordship wishes and the expectation of the person who is in the judicial custody. That is wrong. That is wrong. I have independently having come across the social media report. It was brought to the notice of the police. Now, the second issue is, in so far as the second case is concerned, where I have sought for further investigation. When I approached, please let me complete. When I approached this honorable court, the investigation was going on. It was not complete. Once I approached this honorable court, investigation was completed and charged.
Yes.
Your Honor, kindly see the charge sheet at column number 17. Column number 17 will get it. Because the investigation is not so far completed. That is what the charge sheet, Your Honor, kindly. I just read that because the accused number 7, the accused number 6, he was in a judicial custody when the charge sheet was filed. Because under section 167, because the charge sheet has to be filed within a particular period of time, right? 60 days or 90 days, as the case may be, depending upon the gravity of the offense. Otherwise, they will get a statutory pay. The person will get a statutory pay. In the background of that, you also may kindly see the observation of the noting of the investigating officer in the charge sheet. ಈ ಕೇಸಿನಲ್ಲಿ ಆರೋಪಿ ಆರನೇ ಆರೋಪಿಗಳು ಆರ್ನಿ ನ್ಯಾಯಾಂಗ ಬಂಧನದಲ್ಲಿದ್ದು ನಿಗದಿತ ಸಮಯದ ಒಳಗಾಗಿ ಅಂತಿಮ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಬೇಕಾಗಿರುವುದರಿಂದ 1 ರಿಂದ 7ರವರೆಗಿನ ಆಪಾದಿತರ ವಿರುದ್ಧ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಹಾಗೂ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಇನ್ನೂ ಹೆಚ್ಚಿನ ಸಾಕ್ಷ್ಯಾಧಾರವನ್ನು ಸಂಗ್ರಹಿಸುವುದು, ಇತರೆ ಆರೋಪಿಗಳ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರವನ್ನು ಸಂಗ್ರಹಿಸುವುದು, FSL ವರದಿಯನ್ನು ಪಡೆಯುವುದು, CGR ವರದಿಯನ್ನು ಪಡೆಯುವುದು ಬಾಕಿ ಇದ್ದು 173 ಕಲಂ 173 CRPC ಅಡಿಯಲ್ಲಿ ತನಿಖೆಯನ್ನು ಮುಂದುವರಿಸಿರುತ್ತದೆ. Investigation is not completed in principle, it is not completed.
All right, we will consider your prayer in that writ petition.
No,
We will consider.
I'm for a moment, I'm not saying that my lord, my petition, the second petition survived from the consideration. Survived from the consideration. I'm referring to this. Even in supporting my lord's the argument of this senior counsel, Mr. C.V. Nagesh in connected manner, because I'm my lord's holding the brief on in that case. Because in the background of that, the investigation is still going on and the material has to be corrected. And my lord said, now at this stage, my lord, my humble submission is, it is premature for the elite court to say that my lord's case is not made okay.
All right. Yes. Word reserved. ಅವ್ರದೊಂದು ನಾಳೆಗೆ ಹಾಕ್ಲಿ. All other matters will come up after vacations.
Thank you.